Weekly list item number 1.
Yeah, pleasure, Lordship. Kind permission.
Just yes.
My lord, kind permission, my lord. Here the petitioner is my lord is already being convicted and remained inside jail custody for about 24 years. Has prayed for my lord's kind interference that his petition my lord, for premature release was rejected by the my lord, government annexure 1, my lord.
You faced trial and convicted
My lord,
under section
under section my lord 395 30 my lord 396 34 IPC and 5 of the Explosive Substance Act, my lord, and 25 of the Arms Act read with 34 IPC. My lord, kindly see page 3 of my brief where I have mentioned about the narration of the case where
no, it's all right. The judgment was pronounced on 17/7/2004.
my lord,
So what about the appeal?
appeal, my lord, was confirmed by
Mm-hmm.
my lord, it is confirmed by the
Where have you
I have
taken?
not that I have
Why?
sorry, my lord, I have not.
What is the CRLA number?
That instruction, my lord, sorry.
Hello.
I'll come with her.
Number 2, why your that application or
Yes.
premature release was rejected on what ground?
That report may not kindly because there is simple one-line rejection. Kindly see
by district authority.
my
What
have not-
adverse report?
the report has not will not submit direct. If they will produce the report.
So far, regarding this report, my lord, there is a report from the superintendent of police regarding, my lord. I am submitting, my lord.
No, have you? It's the first time it's coming.
Last
time.
occasion, my lord,
Time was taken. My associate was there. I am not sorry.
to take instruction. That's why, my lord.
No, you see, we just want to know that so far as this premature release is concerned,
My lord.
whether there is any rules framed
Yes,
or
sir.
there is any scheme,
My lord.
any instruction which
Madam.
is to be followed. That
These are the-
unless there is guideline, it would be purely a discretionary thing.
My lord.
At your whim and pleasure, you can do it. So that is not permissible.
My lord, kindly turn to page 4, my lord.
Page?
Page 4, my lord. Para 6.
Yeah.
Like categorization of prisoners for premature release, my lord. 1, my lord. Having regards to the provision contained under section 433A of the CRPC, the National Human Rights Commission NHRC opined that a reasonable clarification may be made within the category of convicts on the basis of magnitude and brutality and gravity of the offences for which the convict was sentenced to life imprisonment, and accordingly certain category of life conviction prisoners other than those mentioned in clause A to E below may be eligible for premature release after the completion of 20 years of imprisonment, including remission, my lord.
He falls on which category?
He falls in, my lord, because in A, my lord, kindly have a glance on the A, my lord. A category is the docility with murder, my lord. The 4th line, my lord. And for that, my lord, kindly come to page 5. Provided that categories of like convicts mentioned in clause A to E may be placed for concession for premature lease after completion of 25 years, madam. So that will be only after the 25 years it will be considered, madam.
Yes.
My grievance
Is it
will
24 years?
Gopal Gowda similarly placed accused convict was granted
But
Milord.
your case is after 25 years he is entitled
Entitled.
for week to consider.
Madam. And after that also one report was called for from the SPs and the police department whether premature is for the law and order situation. That's why the report was called. And against him, my lord, there is a report that there is every chance of.
No, we are two things arises. The rejection as it appears from annexure A
My lord.
is not because of this resolution of the.
Because of the
This is
report,
not. This is
adverse
not the
order.
reason.
Adverse report, my lord.
Because what he says that another
Gopal,
person
my lord.
who was also convicted
My
of same offense,
My
his
lord.
appeal was also dismissed.
Yes, madam.
He has been released.
Released,
So
madam.
the-
Because
the
his
only-
report against him, the report was that there is no.
So then you don't rely upon this, you rely upon the report.
Now this is on the report basis he has rejected, my lord.
No, suppose, let us come to that. Let
Madam.
us say that that means once you are releasing a person who has not even completed 25 years of service, in this case, a co-convict, that means you are not following this one.
No, it should be followed, my lord.
No, you are not following.
But
But that,
my lord,
person would
this
not
is-
have been released prior to 25
Yes,
years.
that's true.
So that means you are strictly not following it. Number one. Number two, if you say that for adverse report of the district authority,
My lord.
that can be rejected. Why is that?
My lord.
There is a report of also jail authority paralegal his annexure 4.
No, we are, suppose let us say that adverse report is there. We are accepting whatever.
My
it
lord.
is. Consideration, what we are asking you that whether that can be taken into account while rejecting this petition or application for premature release, whether that is to be taken into account, whether that is there in your resolution or whatever guideline. If that is not there, then
My lord.
that would be an extraneous thing.
My lord.
Now, 4 people were convicted for the same offense.
My lord.
What about the other 3? Have you released them?
He has taken our
Out of
one has been
other two has
but he has taken, at least he is not disputing that one has
One
been
has been.
released.
Same
Last
sentence, same.
Same,
same
Milord.
sentence because the- and
Omnibus allegation not proved. All Milord, they have gone to bank.
And number, Mr.
Madam.
Suppose something is there against him.
Madam.
You say that it's an adverse report.
My lord.
Then it should be brought to the notice of the person concerned to have his say. You cannot unilaterally say on your own that these are the adverse report. So without giving any opportunity to him, you will utilize that against him.
My lord. Understand.
Because as we find that it doesn't appear that any opportunity has been given to the convict to have his say on this one line you have mentioned that you just see the reason what you say adverse report, what has been mentioned here.
Legally law and order.
Page 15, clause 9.
Nine,
No,
that-
I'm not.
that's-
Oh, sorry.
Adverse
report
report
of
of
operation.
adverse report, it is adverse report.
I get
Where is that adverse report?
My lord, that is page 1, my lord.
Page 1 में लिखियन the
The
law and order problem cannot be ruled
ruled
out
out.
if Tarkeswara released on premature.
Mature.
Hala, number 1. On inquiry in locally, there is apprehension of keeping personal grudge over complainant and family by a convict. Number 3, convict may not lead a honest livelihood. This is written by the Superintendent of Police Raurkela. So it is based, as you was observed, that IIC RN Palli Police Station, he was entrusted for an inquiry, and he perhaps has submitted this report basing on which the SP has heard. That is, question is that when this report has been utilized, when an inquiry has been held and IIC has prepared the report, whether it is not necessary on the part of the authority to provide him that copy of the report, give an opportunity to the concerned convict to have his say. Otherwise, it would be behind his back. Everything you can take that. Suppose the IIC has some bias or something like that. He has some, maybe that he is influenced by the informant's family member.
Informant is a bank officer. He must
So
have read
he can give such a report. There is no problem. But he should have a say.
What is the procedure?
My lord,
What
page
is
7,
what
my
is the
lord.
procedure contemplated under this
My lord,
guideline?
that
How
is-
do you proceed?
My lord, page 9, my lord.
Page 9 of the
My
guideline.
lord, my report, my lord.
Guideline.
Is,
Guideline.
Gazette guideline.
Page
Proceed.
13.
9, my lord.
Procedure.
Procedure for processing of the cases for consideration of the review of the board, my lord. Can it pass over, my lord? Better, I will I will clarify the
No,
queries, my
you
lord.
have not filed any counter affidavit.
No, I have not filed. If my lord direct, I will file.
You
And
have to
humbly-
file it. How
Humbly
can it
pray.
be decided?
One of the reason they have mentioned what I gathered, the informants.
So let him file. You can file. your
Informant is a
joint
bank
affidavit.
officer. He
It's all
then
right.
bank officer informant. Whether he was given any.
Whether this adverse report which you have obtained, whether you have followed the guideline procedure or not, that has to be
Yes, ma'am.
spelled out in your counter so that
Ma'am.
we can.
During this writ petition in the nature of habeas corpus has been filed by the petitioner Nilu alias Tarkeswar Kumar Chaudhary for quashing the order dated 2/2/2023 passed by the
DIG, that is
Deputy Inspector General of Prisons Headquarters
Annexure 1.
under Annexure 1 in rejecting
Premature release.
is in rejecting his case for premature release from jail custody. It appears from the averments taken in the writ petition that the petitioner faced trial in the Court of London Additional Session Judge Raurkela in ST number 118/45/2001, and he was found guilty under section 396 of the Indian Penal Code, section 5 of the Explosive Substances Act, section 25 of the Arms Act, read with section 34 of the Indian Penal Code, and sentenced to undergo imprisonment for life. The judgment was pronounced on 19/7/2004. It is further stated that the petitioner has completed 23 years as a convict in jail, and during stay in the jail, he has been released on interim bail for 1 month, and thereafter he surrendered as per the direction of this court. The learned counsel for the a specific averment has also been taken that one of the co-convict, namely A. Gopal Mahakur, who also sentenced to life imprisonment for similar offences, has been granted premature release by the Directorate of Prisons and Correctional Service, Odisha, by memo number 20010/J/R/89/2014 dated 21/11/2019. The learned counsel for the petitioner, Mr. Lalitendu Misra, argued that as appears from Annexure 1, the ground of rejection by the State Sentence Review Board, which was held on 13/1/2023, was on the sole ground of adverse report of district authorities. When a query was made to the learned counsel for the state as to whether there is any rule framed, any scheme of remission or instruction issued by the government in this respect, the learned counsel for the state drew our attention to the resolution dated 19/4/2022 of the Law Department, which was published in Odisha Gazette, wherein in clause number 6, it has been held that convicts who have been imprisoned for life in case like dacoity with murder, their case will be considered after completion of 25 years of incarceration. Since, as per the averments taken in the writ petition, the co-convict
Gopal Mahakur.
Gopal Mahakur.
Gopal Mahakur. That is not
A. Gopal Mahakur.
No, that is not a maybe.
Only Gopal Mahakur.
Acha, Gopal Mahakur.
Previously also, my lord, that
Gopal Mahakur was released prior to the completion of 25 years of incarceration, we are of the prima facie view that the government is not strictly following this resolution dated 19th April 2022 while considering the case of premature release. In case of live convicts mentioned under clause A to E, the guideline to na likhi do that is guideline for premature release 2022. It is a resolution no lekin seta At this stage, the Learning Council for the state pointed out the adverse report against the petitioner which indicates that Superintendent of Police Raurkela entrusted inquiry to IIC RN Palli Police Station on the premature release proposal, and the inquiry report was submitted which indicated that law and order problems cannot be ruled out if the petitioner is released on premature and there is apprehension of keeping personal grudge over the informant and his family members by the petitioner, and that the petitioner might not lead a honest livelihood. When a further query is made to the Learning Council for the state as to whether there is any provision in the guideline for premature release 2022 to take into account such adverse report while considering the premature release, whether copy of the inquiry report of the IIC RN Palli Police Station was supplied to the petitioner to have his say on the matter, and whether the petitioner was given any opportunity of hearing.
May I pardon for one thing? My lord, page 10, my lord, can I have glance on the resolution, my lord. That law dependent resolution, my lord. Page 10, para 4B. In case the Superintendent of Police is not in favor of the premature release of the petitioner, he shall justify the same with congruent reasons and materials and shall send the reference keeping in view of the
My lord, view. Yes.
That as per
Where is the material? Where is nothing?
that report was the basic.
And just see the language. You say that his
Madam.
premature release may not be considered.
Madam.
And who is the board? Board consists of many members. Just
Yes,
see.
sir.
And you advise them not to consider.
Because prior to
The
that,
board as per the constitution of board is 2.
Superintendent of the jail will
Clause 2.
process the.
You can place it all material
yes,
before the board. I can understand. But who are you to say that don't consider? See the language of.
Yes, obliged. That is the.
You say that don't consider.
He has to place.
Last, let's see. May not be considered. Whether it should be considered or not, the board will take the call.
Obliged.
You place the material before them.
The language is also something different, Mr. Das. Or eta jota from place kurchunti. That is completely different. On receipt of the reference mentioned under section so and so. So 3B means subpara 3B, where the prisoner was ordinarily residing at the time of commission of offense is
3B ne,
different
4B
from
madam.
this one. So
4B.
four.
4B madam.
In case the superintendent of police is not in favor of premature release of the petitioner, he shall justify the same with cogent. No, prior to that, you are to read 4A.
Madam, that
On receipt of the reference mentioned in clause so and so,
madam.
the concerned superintendent shall cause an. So this empowers the superintendent of police to cause an inquiry,
Madam.
right?
Madam.
And that inquiry is to be made through the senior police officer
But
of
here
an
the inquiry
appropriate
is done
rank,
by
and based on his own assessment
Madam.
shall make his recommendation, and while making recommendation, the superintendent of police shall not act mechanically or oppose the premature release of the petitioner on untenable and hypothetical ground of apprehension. That means, suppose he has ordered for an inquiry and the inquiry report is received.
Madam.
Merely following that inquiry report, he has not to pass the order. He has to make his own assessment
Madam.
whether that inquiry report has to be accepted or not. That means independent application of mind is necessary. Then the superintendent of police, then comes this one. Suppose he is not in favor of the premature release, he shall justify the same with cogent reasons and materials and shall send the reference keeping in view. So that part is there.
Madam.
So you cannot just say you have to assign the reasons, not basing on the report which has been prepared by Mr. X or Mr. Y. That IIC gave the report, you just said that he should not be released on. That should not be the approach. The approach is something different, as has been mentioned in the guideline. So SP is obviously empowered by virtue of this to may hold an inquiry. Hello? But after, who is to hold the inquiry and how, what he has to do after receipt of the report, that is also been let down. That is not seems to have been followed by looking at this one.
And what are the materials available to you to arrive at this
अच्छा,
conclusion?
एक और लिख लो तो जो लिख लो नहीं, so whether there is any swan. So
whether the
the
informant
Learned and
bank
Council
manager
for
will
the state referred to, that is
under
7. That is
4B.
7(4)(b).
7 bracket लिखो to 4 bracket रे A and B लिखते हैं, A and B, है ना? Of the 2022 guidelines ना कहते हैं बेटा? 2022 guidelines से ऊपर लिख दो hereafter 2022 guidelines, है ना? But on going through the same, we find that in the case in hand, prima facie, the said procedure has not been followed in letter and spirit. Be that as it may, no, the Learned Council for the state submits that he will file an objection, counter affidavit to the writ petition, and he may be given some time. Put up this matter. Acha, I would actually line like the Learned Council for the petitioner was asked as to what happened to the criminal appeal preferred by the whether any criminal appeal has been preferred by the appellant, and if so, what is the result? He submitted that he has instruction that criminal appeal has been preferred before this court, and the same has been dismissed. But he wants to file an affidavit to that
confirm.
effect,
I will
giving
confirm. Check out.
the numbers and date of disposal, etc. So list this
At
matter.
the time of the process of the premature malad, he was under only 22 years. That is not 24 years, not that is exactly 22 years malad.
नहीं सी लिखता
government
गवर्नमेंट नहीं चाहिए 23 years. We have just put
because I have a
government report also shows 24.
24.
that is wrongly it has been mentioned because this is a custody report. madam.
You in the counter, you are dealing.
No, you will deal with that.
I'll-
One more submission, my lord. Now he's as per the welfare, we did not record. I got some WhatsApp message from the welfare officer from the jail.
I know how to my
That may not be
the-
welfare officer has a role.
My lord, release on bail, my lord. Gopal Makur is released on bail after the report submitted by the police officer, premature release. Just after few days, he was murdered, my lord.
He was murdered.
Murdered. Okay. And that is also another, it is what I was discussing with
that-
them.
You see, wherever this type of release is there, the condition is that they are to lead a different life. If
Yes.
they flouted it, that can be revoked.
Yes.
There is no that it is for all
Just
time
after
to
few
come.
days, not months, madam.
Ah,
Only after few days of release, he was murdered.
But
No,
that case is
we-
dockety,
we are-
so informant is a bank.
we are concerned with that whether this rejection under annexure 1 it is sustainable in the eye of law
Yes,
or not.
I'll
So we are taking up this matter after 4 weeks. We will give you.
Madam.
So today is 25th. So let it come on 30th of October 2023.
Madam.
You are getting sufficient time. File your counter affidavit, if any, file in the meantime, giving
Three
copy
copy,
to the learned counsel for the petitioner. If he so likes, he can file the rejoinder affidavit. So you
Madam,
do it.
May permitted to annexure 4.
Argue the matter when the matter is
That
final.
report I may praise. The report from the
You
jail.
want to file rejoinder? File rejoinder.
Obliged. I'll file. But now he's imparting education since last 12 years.
Give the how many sets of copies you are to give. How many opposite parties are there?
My lord,
Okay, 3 sets.
my lord, only
okay.
3 sets to
3 sets of writ petition be supplied to the land council for the state. Yes, next.
grateful, my lord, obliged.
Item number 2,
For the issue notice on the question of permission, so on so. Individual.
I will please your lordship.
Yes.
I may please your lordship. Well, the petitioner's daughter went to nearby market on 13th August. Thereafter, she did not return. And 14th, the petitioner came to know that his mobile last located at Visakhapatnam.
He is 30-year-old.
30 years.
That way. And thereafter, he filed
Who is missing?
a petitioner daughter.
And who are these 4, 5, and 6?
From the Visakhapatnam hotel where we last located his her mobile number, came to know that she was with opposite one number 4.
You have taken averment that he has been
Yes, sir.
wrongfully confined.
Yes, sir.
Which paragraph?
Paragraph 5.
5.
5.
Illegally confined by so and so.
And paragraph 7.
Have you informed it to the police?
Yes, sir.
Where is that? You have just given the missing report.
That was on 15th. I came to know on 17th.
No, any report thereafter given that 4, 5?
Only verbally I have informed that this is the fact.
What this page 15 representation you have made representation, but there also you have not said anything.
No, that is
When you filed this writ petition?
on 8th September.
8/9/2023. This representation is dated 2/9. When you came to know that they have illegally did
17th August.
17th August.
Yes.
So you should
Then why you should have mentioned in the representation?
I should have mentioned because due to lack of petitioner could not know about the.
ଆରେ ଆପଣ ପରା କହୁଛନ୍ତି 17 ଅଗଷ୍ଟରେ ଜାଣିଲେ ଯେ ଆପଣଙ୍କ ଝିଅକୁ A, B, C 3 ଜଣ ଯାକ illegally confined କରି ରଖିଛନ୍ତି, right? ଆପଣ ସେପ୍ଟେମ୍ବର 2 ତାରିଖରେ ରିପ୍ରେଜେଣ୍ଟେସନ ଦଉଛନ୍ତି ସୁପରିଟେଣ୍ଡେଣ୍ଟ ଅଫ ପୋଲିସ କୁ। ସେ ବିଷୟରେ ଯଦି ଉଲ୍ଲେଖ କରୁନାହାନ୍ତି ତାହେଲେ ଆପଣଙ୍କର ରିଟ୍ ପିଟିସନରେ ଆଭରମେଣ୍ଟ ଟାକୁ କଣ ପାଇଁ ବିଶ୍ୱାସ କରାଯିବ ଯେ ସେମାନେ illegally confined କରି ରଖିଛନ୍ତି ଆପଣ?
An affidavit we have shown.
An
affidavit we have stated. The petitioner has.
All right, Mr. Das, I will obtain instruction. This writ petition in the nature of habeas corpus has been filed. With a prayer to the opposite parties search, produce, and hand over the victim, who is the daughter of the petitioner,
Yes, sir.
before this court. The government has been taken in paragraph number 5 that the daughter of the petitioner has been illegally confined by opposite party number 4 and his parents, opposite party number 5 and 6. To the Land Counsel for the petitioner submitted that the petitioner came to know about such illegal confinement on କେବେ କହୁଥିଲେ ଆପଣ?
17th August.
On 17/8/2023. But it appears that even though a representation has been made by the petitioner to the Superintendent of Police Barampur Ganjam on 2/9/2023, the names of the opposite parties number 4, 5, 6 confining his daughter illegally has not been reflected. Be that as it may, the Land Council for the state shall obtain instruction on this writ petition and ଆପଣ ଗୋଟେ ସପ୍ତାହ ଦଉଛୁ ଆପଣଙ୍କୁ ଏ ମ୍ୟାଟରରେ ତ 9th ରେ ଆପଣ ଆଣନ୍ତୁ please this matter in the week commencing from 9th of October 2023. Yeah.
Okay.
Instruction we obtain in the meantime. Yeah.
Item number 3.
Matter relating to habeas corpus. Let's see.
What is your prayer?
Produce
Please adjust the mic.
Produce the elder brother of the petitioner.
Produce the
elder brother of the petitioner.
elder brother. Where has he gone?
Let's see.
You have not given any report or any complaint to the police.
No, let's see.
Straight away file this.
Here, let's see. On 4/9/2023, at midnight, some unidentified persons have
4/9.
4/9/2023. Let's see.
Okay.
Some unidentified persons forcibly confined to the elder brother of the petitioner at midnight. But on the next day, on 5/9/2023, the family members, including the present petitioner, tried to contact with the brother, but they found the mobile is switched off. On the very next day, on 6/9/2023, the brother, the friend of the brother of the petitioner, intimated that he has been confined by the police. But the same fact has not been intimated to the family member of the petitioner. On 7/9/2023, the detained informed one of the relative of the petitioner that he is in the police.
No, you have mentioned perhaps in paragraph number 6, you have mentioned that he is in custody of cyber crimes and economic offense police station, Bhubaneswar.
In next paragraph, in paragraph 7,
Yes.
Can you have a glance?
No, suppose he has been taken into custody in connection with commission of an economic offense.
Yes.
Can it be said that if they have not followed the provision that 41, that's a different matter.
Yes.
But can it be said that it's an illegal detention?
Yes. If he is involved in such a crime,
you have the other options available under law. Suppose you have been arrested in connection with the economic offense, then you have to apply for bail before the appropriate court, and if it is rejected, you can move the higher court.
No, here,
but it's question of illegal confinement to entertain an habeas corpus petition.
Here, they have the fact.
Was he produced in the court? Because as per your own version,
they have produced to the detained on 9,
on
Then
9/7,
what
Lordship.
He is in lawful custody.
Lordship, no doubt. I am not disputing that he is in lawful custody.
Then how
But
can your petition will be maintained?
Lordship, the police has forcibly, some identified persons have forcibly took it to the brother of the petitioner. Thereafter, they disclosed their identity. They are the police persons. On 4/9, they have forwarded to the.
You see, you have suppressed many things. You have
Yes, sir.
not mentioned that he was produced in court, he was remanded to judicial custody, and in connection with this case, even though now you say that you have knowledge, so you should have disclosed all these things, that after being taken into custody by the officials in connection with an economic offense, he was produced in court, then the court has remanded him to judicial custody. So this you deliberately not mentioned to make out a case for habeas corpus.
Take it up next week. I will.
What next week?
I will submit the interfacts, Lordship.
See, 7th, you say 7th he was apprehended. On 9th he was produced.
No,
Rightly.
no, he is not appearing in 7th, Lordship. I
That's-
filed the
that's-
petition
that's-
on 7th, Lordship.
See, para 7
Lordship.
indicates that.
Lordship.
You yourself saying that on 9th of September he was produced before the court.
Lordship.
All these grievances you can raise there.
Lordship, here what they have not forwarded to the petition,
No, the
Lordship.
question is how will you
Lordship.
maintain a habeas corpus
Lordship,
petition?
here that
Right.
the fact has been, the detained has intimated the fact to the one of the relatives of the petitioner, Lordship, not to the family member that he has been detained by the police.
Mr.
Lordship.
You may say so,
Lordship.
but they will have proof with them that all the formalities have been complied with. Question is not that. Question is that when your knowledge is there that he has been taken into custody in connection with a case and produced in court, remanded to judicial custody, whether it was not necessary on your part to make all those statements in the petition just to make out a writ of habeas corpus. How can you just withheld those vital information from the court?
So it is not directly knowledge to the family member of the petitioner and also the petitioner.
It is not.
The fact has been brought to the knowledge of the friend and the other relative.
What do you want? This is not maintainable. What do you want now?
Next week, Lordship, I will take the instruction.
All right, for your satisfaction,
Lordship,
we are keeping it.
Lordship,
Maybe that bail application might have been moved in the meantime
Lordship.
before the concerned court.
Rather
It
you
is,
concentrate there, he
Right,
get the
right.
bail.
Necessary.
also little confusing because this Assis Satpathy jaku kouchandi saying
Hmm.
he himself has come and said ki amaku nei jaitile. But next parare kouchandi petitioner phone ki kouchandi mu au Assis samadhi jan ko bandhi ki
No,
rakhi.
it appears that he was taken into custody in connection with an economic offense.
It's
Prima facie,
prima facie doesn't
because
come
the officials they are this economic offense wing, they have come and taken him to that appears from. All right, the Learned Counsel for the petitioner 6 adjournment till next week. Publish this matter. We commencing from 3rd of October 2023. Yes.
Item number 4.
May it please your lordship. It's a pleasure to see your lordship.
Thank you.
My lords, here the question that I am raising before your lordship is, my lords, 409, my lords, if your lordships may straight away come to section 409 of the IPC, my lords. 409 is very
Say CBI matter.
Yes,
yes,
Your
my
Lordship.
lords.
So where is the
Your Lordship, Mr. Nag is on his legs in another court. Your Lordship, we have also not yet received instructions in the matter. Your Lordship may kindly give us some time to seek instructions.
My lords, I'll just
Let us just hear it.
Yes,
Yes,
sir.
sir.
the question that I'm formulating is, my lords, 409, my lords, the wording is very peculiar. My lords, whoever being in any manner entrusted with property or with any dominion over property in his capacity of a public servant or in the way of his business as a banker, merchant, factor, broker, attorney, or agent commits criminal breach of trust in respect of that property shall be punished with imprisonment for life or with imprisonment of either description, which may extend to 10 years and shall also be liable to fine. Classification of offense. The offense under this section is cognizable, non-bailable, non-compoundable, and triable by magistrate of the first class. This offense is triable by the magistrate of the first class as per the section itself. If the magistrate feels that I do not have the capacity to give sufficient punishment, at best he can recommend this case under 325 to the CGM. CGM can impose a maximum period of 7 years. So, my lords, in its application to the state of Orissa, once it is triable by a magistrate of first class, and it can be referred to the CGM who can only impose 7 years. So 7 years is the maximum that can be imposed upon this person in an offense under 409. My lords, if the state wanted that no further punishment can be imposed, like in Madhya Pradesh, they brought about a state amendment making it triable by the Sessions Court. This matter was raised in a 436A application, my lords, before this honorable court. But this honorable court held that 436A does not have an enabling clause. So he is not entitled to bail. But now he has completed his 7 years of imprisonment.
No,
7 years, 6 months.
409,
Yes, my lords.
it prescribes life imprisonment.
But my lords, if it is triable by magistrate first class.
No, triable by magistrate, but it is being tried by now Special Judge CBI Bhubaneswar, because the case is being investigated by the CBI, and obviously whatever investigation is made by the CBI, that is to be tried by the Special Judge CBI.
My
So
lords,
he can impose life sentence also.
my lords, what I am saying before your lordship is, my lords, if your lordships will have to adjudicate this point.
Yes.
If there is an interpretation in favor of the accused, that has to be adopted.
No.
This is
Who is trying you?
trying
Special Judge CBI.
special judge
So this
CBI.
question doesn't arise in the
No. Here, my lords, if it is tribal, if this IPC itself provides that this is to be tried by the magistrate first class, even the trial before a special judge, my lords, because there is no section authorizing a special judge or any other superior judge, because, my lords, if a judge is not authorized
You
to
see,
try that offense,
the procedure
my lords,
which has been let down in the
IPC.
CRPC so far as warrant case is concerned,
Yes, my lords.
that is to be followed in this case.
Exactly.
Not the sessions tribal cases. Sessions tribal procedure is something different
My lords.
than the other cases.
My
So
lords.
here, when CBI court the matter is pending,
My
and
lords.
409 IPC prescribes life imprisonment.
My lords.
Question is that whether you are to be released, and how can it be said that in a writ of habeas corpus would be maintainable when it would be maintainable? Suppose you have already undergone the maximum sentence prescribed for any of the offense.
Yes.
Okay.
Yes.
Then you can say that even if I am convicted in future,
My
I will not be detained. So I have already undergone.
Yes.
So my detention at this moment is illegal.
My lords.
The matter is something different.
Yes.
But here one of these offense is 409,
Exactly.
which you know that it's a life imprisonment is there.
My lords.
Yes.
I'm coming to that only,
Yes.
my lords. My lords, the IPC section itself in the classification of offense
Yes.
says it is triable by a magistrate first class.
Right.
If it is triable by a magistrate first class, the section itself, your lordships were C409.
No.
Classification of offense.
It's magistrate tribal. Nobody disputes about this. But question is that, Mr. Certain cases were decided by the Honorable Supreme Court
My lords.
in 2014
My
that
lords.
these are the companies which cases are to be investigated by the
By the
CBI,
CBI.
right?
Exactly.
One of such companies is Rose Valley. Right.
Roswell. Yes.
And in pursuance to such order,
My lords.
the CBI is investigating the case not only against Rose Valley but also against other.
My lords.
Now, once they file the charge sheet, obviously the trial is to be held by the CBI court, not by the magistrate court, right?
My lords.
So if the CBI, can you dispute that the CBI court has no power to sentence a person to life imprisonment?
My lords, there is a CGM post also there.
No. Question
There are two posts, my lords.
The CBI court, that is a special, that whatever
It is under the
investigation-
special statute.
right. So it
Yes.
is to be
Under the
investi-
Delhi Police Act.
right. So that is to be, that is why the CBI courts are
Yes.
there. So this special judge is there to try the case, and this special judge is also empowered
My lord.
to sentence you to life imprisonment. So which is not permissible for a magistrate. Even the CGM, as you rightly said,
My
that
lord.
the CGM cannot pass such a sentence.
Yes, my lord.
But a special judge can pass such sentence.
My lords, my humble submission before your lordship is just this.
Yeah.
My lords, when the IPC itself says it is to be tried by a magistrate,
Yeah.
when the CRPC says this is the maximum punishment that can be imposed, now there may be a special judge CBI is trying the case,
Right.
but can he go beyond the punishment as given here, my lords?
We are not on punishment. We are totally different.
No,
He may impose 7 years. He may impose 10 years. He may impose 3 years. Who knows?
no, that's
question
a
is
separate issue, my lords.
Your trial is now going on.
Now he is
you are-
already
you-
behind bars for almost 8 years.
You may have a good case on merit or legal issue, but
legal.
in so far as the facts of your case is concerned,
My lords.
I don't think
We are concerned with a habeas
Habeas corpus
illegal
writ. Exactly,
detention.
my lords. I'm
Then
just bringing it.
you
And,
are-
and there is another thing, your lordships may kindly see in the section itself. Maybe shall be punished with imprisonment for life or with imprisonment of either description which for a term which may extend to 10 years.
By
Now, my
the
lords,
way,
they don't
Mr.
say.
Kanungo, what is the status of this case now?
My lords, 7.5 years have passed. My instructions are that charge sheet has not been filed. Final charge sheet has not been
No,
filed.
if your bail application has been rejected by this court
Yes, Your
Yes,
Lordship.
after
Coordinate
8
fine.
years, then-
after
Your Lordship,
after 7 years it was rejected.
it was
then
rejected on 28
your
March.
remedy lies in Delhi, not here in a
No, my
different.
lords, I am raising this point before your lordship because it is. I also get your lordship's point that because it's a CBI court. Under normal circumstances, we have a EA case, my lords, because the CGM can only impose a punishment of 7 years, and already he's behind bars for 7.5 years. So, my lords, under normal circumstances, what your lordship is
Delhi is
saying
not
that it is a CGM,
Delhi-
CBI court.
Delhi is not unknown to you as my
No, well, it's very familiar to your lordship, not unknown to us, my lords. I'm just pointing this out before your lordship. Your lordships may take whatever. This is the otherwise. Your lordships may allow me to withdraw this application for
Mr.
filing
Mukram
a bail.
Kanungo, land senior advocate, appearing for the petitioner after arguing for a long time, seeks permission to withdraw the writ petition. The writ petition is disposed of as withdrawn.
Your Lordship, if I may pray presence of Mr. Naik.
Mr. Sarthak Naik, land special public prosecutor, CBI. Though he is not present, I will record it.
I pray.
Yes, come to the court now.
Yes, Lordship, Mr. Naik is on his
100% sure.
Yes, Your Lordship,
Okay.
he's on his.
All right.
Deeply obliged.
I'm much obliged, Your Lordship.
Item number 5.
May please your lordship, my lord. Let the father with your lordship, lord, for the habeas corpus petition in the Potable lordship for illegal detention of his daughter, my lord, with the opposite part number 4, who was kidnapped and
What is the age of your
16 plus, my lord. Annexure 1 is my certificate, school certificate.
29/4/2006.
Pardon?
29/4/2006.
6 ହେଲେ ତ 17 ବର୍ଷ କମ୍ପ୍ଲିଟ ହେଇଗଲାଣି 17 ବର୍ଷ
By now, my lord.
5 ହଁ ନାଇଁ ନାଇଁ ବର୍ତ୍ତମାନ ହଉଛି 17 ବର୍ଷ 5 ମାସ ଚାଲିଛି already. Okay. Have you lodged any FIR?
Yes, I have lost the FIR, my lord. Also, I have also made representation to the superintendent of police, but in
Have
vain.
you
Government taken that illegal detention by OP number 4, my lord.
okay, that boy is opposite party number 4.
4, my lord.
And who is this OP5?
I be the father because
All right, you obtain instruction.
Well-
এটা ফার্স্ট টাইম আসছে না?
yes, my lord. First
The
time.
land council for the state takes some time to obtain instruction in the matter. Out of this matter. Say 9 तारीख को আসছে 9th of so and so. Yes. And you produce the case diary of that case. What is the case number?
My lord, PS case number, my lord. 187, 87
The Land Council for the state shall produce the
period
case diary of Pirohat PS case number 187 of 2022. Yes, next.
oblige, my lord, diplomat.
Item number 6.
I may plead your lordship. And here the wife is for your lordship on the allegation that her husband, while returning from office, under the impression that some cases are pending and the Lakshmisagar police stations, the officials of Lakshmisagar police station, they took the petitioner, husband of the petitioner. And when the petitioner went to the police station to know about the case and to take some follow-up measures as available for her, she was informed that her husband has been remanded to Lakshmisagar jail, Jharpada jail. And upon visiting to the Jharpada jail also, they given the impression that no such person is there in the Jharpada jail. So the petitioner went to lodge a complaint before the DCP Bhubaneswar, alleging narrating all the facts that has been annexed 1 page 10, but that report is not accepted.
No, it's all right. Which, according to you, which police station officials took your brother or husband?
Lakshmisagar, madam.
Lakshmisagar. When, what is that date?
That is 23rd of August 2023.
He has not yet been produced in any court.
No, my lord. And the whether say he has been arrested or any connection with any case or all these things. I went to the Jharpada jail to take follow-up steps. So along with Bhakalatnama, if any he has been detained in custody, I will go to and
yes, Mr. Tripathi. Obtain instruction from this Lakshmisagar police station. What has happened to? And better you will take up this matter next week. But if he has not been produced, even though he was taken into custody on 23/8/2023. So if he is in connection with any case and taken into custody, he should be produced within 24 hours. Right. So, all right, Land Council for the state seeks some time to obtain instruction, specifically from the inspector in charge of Lakshmisagar police station regarding the annexure 1 and also about the averments taken in the writ petition, list this matter on 3rd October 2023. So, Dr. Pachardi on the corner. Yes.
I'm good.
Item number 7.
May I please, your lordship, my lord, interim, my lord, for IA for bail. And here, my lord, life sentence, my lord, imprisonment for life, as well as fine of rupees 2,000, arise for 2 months in default of payment of fine of.
What is the offense for which
offense, my lord, 302. And my lord, here.
You are in custody since when?
My lord, I have given the death chart, my lord. I am in custody since 2010.
What is the death chart?
My lord, I have given, my lord.
Death chart.
9/2/2010. I am in custody. 9/2/2010.
You have never been released on interim bail?
I am released on interim bail for a period of 2 weeks to attend the option ceremony of my father.
By
this honorable court.
What is the order dated?
That order dated, my lord, 20. That, my lord, 5/11/2021.
5/11, okay. 2 weeks you are granted.
And
you surrendered at right time?
Yes, my lord. In time, my lord, he surrendered.
So, as it appears, if it is 9/2/2016, you are in custody.
My lord.
So, that means 7 years and...
my lord, I am in custody since 9/2/2010.
Oh, 10, achha.
10, my lord, 2010.
Then, right. Then it is 13 years and some, okay.
And my lord, one of the
your bail application was earlier rejected.
Yes, my lord. Yes, my lord.
What is the order dated?
That my bail application.
On merit, your bail application.
Yes, my lord. On merit, my bail application
on
was
23rd 4 2015 once.
Just 23rd
4/2015,
Okay,
and next is on 27/9/2019.
27/9/2019.
And my lord, 5 persons, my lord, they face trial. And my lord, out of 5 persons, my lord, I have preferred this appeal for
No, it's all right. Your bail application has been rejected on merit.
my lord.
We are now the question is that you will be released only on this detention period of
Yes,
detention.
my lord, but
Any other criminal antecedent?
no, my lord, no criminal antecedent. And standing on the similar footing, one of the co-convict, my lord, he has already released on bail. His file is also there, my lord, in 405.
40?
405, my lord. That the order has already been attached in this appeal, my lord. And my lord, the persons against whom
Just a minute, let us see that. 405 रो काई कौन पूछन दिखला
Criminal Appeal 405,
এরকম লাগিয়েছে আদের রচ্ছি
Order
আসলে
dated
dated 6/8/2014. But
আচ্ছা 405 টা তো হ্যাঁ এইটা
but co ground রয়েছে my lord, সেই ground টা
405 got a beetle sworn to and he has no criminal background, so committed crime by trespassing is not believable. But it was conducted. All right, some ground has been taken, but your bail application was rejected on merit. So, Mrs. Patnaik, any
Yeah.
criminal antecedent again?
সে পার্টটা নাহি
No.
criminal antecedent
Have you
তো নাহি
got
যেহেতু
those decision where it is stated by the Honorable Supreme Court that after 10 years you can be Surendra? So there are a number of decisions on this one. Why are you not coming? Surendra, why are you not coming prepared?
my lord, and the persons, my lord, who assaulted, and he's also one of
decision ଅଛି Honorable
ହଁ,
Supreme
my lord.
Court ଦ୍ୱାରା 10 ବର୍ଷ ଯଦି ଇଏ ରହିବ ବେଲ୍ ରେ ଯିବ ବୋଲି ସେ decision କାହିଁ ଆପଣ ଆଣିନାହାନ୍ତି ପ୍ରିପେୟାର ହେଇ ଆସିନାହାନ୍ତି ଆପଣ then there is another decision of this court, Letty versus State, where the division bench has stated that if it is not come within that exceptional cases, then you are to first release for 3 months, and if your conduct is good, then if Letty versus State said 91 OCR well that's a decision of Justice T.L. Hansari and Justice R.C. Patnaik.
as far as the other accused is concerned, ତାଙ୍କ ପାଇଁ we had specifically called for the antecedent and there was no adverse
Just to see this
but
decision.
ଆଙ୍କର ଆମେ ଆଣିନୁ but
This decision says Letty, L-E-T-I, huh? Yeah.
पूरा जजमेंट नहीं किया चाहिए।
Your Lordship is probably referring to that Rashidul Zafar
No,
latest
That Surendra, first case is
22
that Surendra, that
2022
it
case.
stated
Surendra
that
Anti.
5 years that was there, and recently also in
10 years যেটা 2022 টা 10
There are
years
many judgments.
many ବହୁତ ଅଛି এটা batch of cases
এইটারে
decide ହେଇଥିଲା
ସେ ଯେହେତୁ ଆଣିନାହାନ୍ତି ତାଙ୍କୁ 3 ମାସ ଦିଆହଉଛି ଏଇ ଡିସିସନ କୁ ରିଲାଏ କରି ସେ ନେକ୍ସଟ ଟାଇମ ପ୍ରିପେୟାର
ଆଜ୍ଞା।
ହେଇଯାଉଛି। ଦେଖନ୍ତୁ the learned counsel for the petitioner submitted that
My lord, my lord, my submission, my lord, that 3 appellants are there before your lordship. Out of 3 appellants, my lord, that appellant number 2 has already been died while he is in
ଆପଣ
custody.
ଏଇ ଯୋଉଟା ଫାଇଲ କରିଛନ୍ତି ବେଲ୍ ଆପ୍ଲିକେସନ ଟା 1950 of 2023 we are passing order on that, ସେଟା କାହା ପାଇଁ ଫାଇଲ କରିଛନ୍ତି, ଏଇଟା କଣ ଫାଇଲ କଲ?
but there interim application ପାଇଁ ସେମିତି କିଛି grounds ଦେଇନାହାନ୍ତି it is as good as filing a
Where is the that 535
1950
535 ର ସେଟା ବାହାର କର ଯୋଉଟା ଫାଇଲ ଅଛି କନସିଡରେସନ ପାଇଁ 1950 ଓକେ ଏଇଟା ଆପଣ କାହା ପାଇଁ ଫାଇଲ କରିଛନ୍ତି?
My lord, 3 ଜଣଙ୍କ ପାଇଁ rest of the 2, my lord.
ନାଇଁ ନା ଆପଣ ଖାଲି ଅନ୍ତର୍ଜମୀ ପାଇଁ ଫାଇଲ
ନାଇଁ,
କରିଛନ୍ତି
ମୁନ୍ନା ଅନ୍ତର୍ଜାମୀ and others appellant are in custody. ସେଇ judgment ରେ 3 ଜଣଙ୍କର ଯୋଉ ଆମେ ଫାଇଲ କରିଥିଲୁ, my lord.
ଟିକେ just a minute, ଆପଣ କ୍ରିମିନାଲ ଆପିଲ କେତେ ଜଣ ପାଇଁ ଫାଇଲ କରିଛନ୍ତି?
My lord, I have filed this criminal appeal
For
for
3 persons.
3 persons. Out of these 3 persons, my lord, appellant number 2, my lord, namely Bhimo Singh,
Okay,
aged about 20 years, son of Udhu Singh, has already died, my lord.
okay, now
Now, my lord, rest remaining Munna alias Antarjami Patra and Surendra Naik alias Surendra Naik.
okay, acha IA number 1950 of 2023, this
ମାନେ 1950 is actually interim bail ରେ କୌଣସି ଏମିତି କିଛି ground ନାହିଁ for interim bail it is as good as in the guise of a regular bail by
Relax for a judgment.
only relying upon the judgment
the learned counsel
bail by
this interim
এটা interim bail
application has been filed for bail of appellant number 1 appellant number 1 Munna alias Antarjami Patra and appellant number 3 Surendra Naik alias Surendranath Naik. The learned counsel for the petitioner submitted that the petitioners are in judicial custody since kebe koile data
My lord, since 9/2/2010.
9/2/2010, and they have already undergone more than 13 years of sentence by now, and the case is not ready for hearing and paper books have not been prepared, and therefore the bail application of the petitioners may be favorably considered. Learned counsel further submits the bail jaitla joda period ta ko date re kohujeni
My lord, that he was released on interim bail.
kiye
My lord, that Munna alias Antarjami.
acha he further submit that the appellant number 1 Munna alias Antarjami Patra was released on interim bail for 2 weeks
My lord.
in IA number 1102 of 2021 as per order dated 5/11/2021, and after availing the same he surrendered at right time. It is the Bhitterpuri zone, है ना? The land counsel for the state doesn't dispute the period of detention of the petitioner in judicial custody. However, submitted that twice the bail application of the petitioner have been rejected on merit, once on 23/4/2015 and then on 27/9/2019. Stop. In case of Leti alias Jayadev Rai and another versus state reported in 1990, volume 3, Orissa Criminal Reports 4-7. A division bench of this court has been pleased to hold as follows. Quote paragraph number 21. Considering the ratio laid down by in the case of Leti, bracket supra, and the fact that both the petitioners have already undergone 13 years of sentence, we are inclined to release the petitioners on bail for a period of 3 months. Which police station they are residing?
Lord,
They belong to
they are my Lord Bangirposi.
Bangirposi.
Bangirposi, Moribhanj.
Auda hochi Jharpokhuria acha.
Aଜ୍ଞା, Jharpokhuria, Moribhanj.
All right. IIC of Bangirposi police station shall keep close watch on the activities of petitioner number 1, appellant number 1, Munna alias Antarjami Patra, and IIC of Jharpokhuria police station shall keep close watch over the activities of appellant number 3, Surendra Naik alias Surendra Nath Naik, and submit a report about their conduct during the period of interim bail to the Land Council for the state. Lest this matter give fixed terms so and so, the Land Council for the petitioner shall produce the so and so, the Land Council for the state shall produce the report on the 3 months ଟିକେ ପୂର୍ବରୁ ପକେଇଦେବା ହେଲା free copy of the order be handed over.
And my Lord, the antecedent report may kindly be called for if any.
All right. See report as including report on the criminal antecedent if any. Yes.
Published.
This don't dispose of this application. It is to be kept pending. Okay.
Item number 8.
Yeah, item number 8 on behalf of Honorable Das, kindly take this matter to acceptance.
The status report this man who has gone missing since 2013. All efforts have been done by the state authorities, by the police to trace him out. But till date, our apprehension is that in order to avoid this conviction in a 498 case, he has kept himself concealed somewhere, because all efforts have been done. Allegations against the wife's relatives that they have kidnapped him, polygraphy tests they have done.
We passed the order on 13/9/2023.
Yeah, I think Lordship had given last.
Produce the son of the petitioner so and so before this court. It seems that first information was lost by the daughter of the petitioner named so and so before IAC Rajgangpur police station against some persons for which Land Council for the state submitted an instruction that investigation of the case is still on and nothing has been found so far. That the son of the petitioner, who is aged about 43 years, at the relevant point of time, has been abducted by anybody, and no material has so far been found against any of the accused persons named in the FIR. So last time we have the assumed up-to-date instruction specifying a case of missing person in view of the ratio laid down in so and so, so and so.
Your Lordships have already decided cases.
Now, what is your instruction?
Instruction I have received, my lord. That exhaustive efforts and endeavors that have been undertaken. CIG publications reward from the Home Department of 2 lakh something has been announced. Polygraphy test of the accused persons. And
last time I believe these for the time.
We called it how it is maintainable with the case of missing person. Which are the relevant paragraphs, Mrs.
My lord, the relevant paragraph is
the final conclusion. What you have said.
My lord, all that you have done, your lordship must see B C, Director of Doordarshan.
This matter was transferred to CBCID.
Yes, my lord. Because
By the order of
your lordships had seen it, though there was no allegation against the police that they were, but however,
Yes, where is your senior?
Senior is not present in the court today.
No, you
the
please
journal.
hand over a copy to him. Let him go through it and we'll take up this matter tomorrow.
My lord.
2013 case, we are not supposed to adjourn it.
My lord.
10 years have already passed. Yes. The এটা খালি খালি নিয়ে আসুন না এটা রিপোর্টটা রখি ଦେଇଥାନ୍ତୁ মানে 5 দিন লিস্ট ଅଛି কালি এটা রাখি it will be called from this weekly list tomorrow, okay?
My lord.
26/9/2020. Yeah.
Item number 9.
Wait, please, Your Lordship. Your Lordship, the present appellant has been in custody since 28/10/2011, Your Lordship.
Bail application.
Yes, Your Lordship. The bail application is Miss Case number 223 of 2017.
You have filed that bail application for appellant number 1.
Yes, Your Lordship. All the other appellants have been released on bail, Your Lordship.
So A1, what is the date of custody of that appellant?
The date of custody is 28/10/2011, Your Lordship.
20th
28 or please.
28/10
Yes.
2011. Okay. How many times your bail application has been rejected on merit?
Your Lordship, my bail application was rejected only once.
What is that date?
That is on 13/13/2015, Your Lordship.
13 to 2000. Let us see that. Period is looking at the paragraph which makes a reference to the oral dying declaration made by the deceased to the doctor. Click करो पर 13. It makes a reference dying declaration, oral dying declaration made by the deceased to the doctor, and also considering the fact that and so on so they are on bail during trial, and their case is distinguishable from the case of appellant number who, according to the dying declaration of the deceased, had poured kerosene oil and ablazed the deceased. We consider it appropriate, so on so. So, okay, oral dying declaration, you are right.
Yes, Your Lordship.
Husband,
Yes,
you
yes,
poured kerosene and set her on fire. That is why your bail application was rejected, whereas the other in-laws family members' bail application was allowed.
yes, Your Lordship.
So now the period is
11 years, 11 months.
11 years, 11 years and 11 months. You are right. See that. So yes, Mr. Melo, যাও 3 মাস যাও দেখন্তু conduct সেই এর পক্ষে লিখি দেবে the land counsel for the petitioner, the appellant number 1, now the Karunakar Mali submitted that appellant number 1 was taken into judicial custody on 28/10/2011.
नहीं है क्या?
And his bail application was rejected on merit on 13/2/2015 in Miss Case number 1890 of 2014. And as such, he has remained in custody for 11 years and 11 months by now. And the case is not ready for hearing and paper book has not been prepared. And therefore, the bail application of the petitioner may be favorably considered. Land counsel for the state oppose the prayer for bail. ତାପରେ ସେ ଯୋଉ ଡିସିସନଟା ଦେଲି ଲେଟି ଏ ଯୋଉ କରି 3 ମାସ ବେଲ ଦେଇଦେବେ ତାକୁ ବି ସେମିତି ପରେ ପୂର୍ବକୁ ରଖିବେ ଏଇଠି ରିପୋର୍ଟଟା ଆସିବ ୟା ଘର କୋଉଠି Binjarpur Police Station.
Yes, Your Lordship.
IIC Binjarpur Police Station shall submit a report about the conduct of the petitioner while on interim bail. Huh? All right. So 3 months bail granted.
3 month 3 month interim bail is granted to watch your
Behavior.
contact during that 3 months. Application is kept pending.
Yes. And no order has been passed on that stay of realization of fine, which is
20,000 rupees.
No, Your Lordship, that
okay,
was
this
kept
case number
pending.
so and so. This is an application for stay of realization of fine. Considering the submission made by the land council for the respective party, there shall be stay of realization of fine imposed by the land and trial court pending disposal of the appeal. Yes.
Much obliged, Your Lordship.
Item number 10.
Item 10, my lord, permit to withdraw matter.
Are you filing any memo or oral?
I will file, my lord.
Eight item kagaz diyo. The land council for the petitioner files memo to withdraw the writ petition. Huh? This case.
This is a disposed of case, my lord. In the disposed of case, they have filed a miscase.
All right. Miscase number so and so, land council so and so. Not press this up. Miscase disposed of has not pressed. Yes.
Item 11.
Yes, Mr. Das.
My lord, on behalf of Mr. Das, in this matter, the victim girl has been rescued. My lord, I think it has been registered before your lordship because there is a cost imposed by this honorable court on respondent number 6, and they went an appeal to the Supreme Court. I think Supreme Court has dismissed it. There's a noting that I think that for that reason only there's an order.
Which order cost has been imposed?
Yes.
Nine 12/2013. Miscase so and so has been filed with a prayer to recall, modify the order dated 28/10/2013 passed by this court imposing a cost of rupees 2 lakhs. Another miscase so and so has been filed with a prayer to stay further proceeding with regard to the proposed punishment. Both the miscase be registered as such. Okay. With the consent of by the order dated so and so on specific finding imposed cost of rupees 2 lakhs on the opposite party number 6, V. Ramachandran, CST Voltaire Secretary of Amopay and Director to pay the said amount to the Chief Minister's Relief Fund. The said amount was not paid by the time fixed. A review petition bearing number so and so was filed by the present applicant to review the order, which was also rejected by this court. We find no reason to again entertain a similar application. We further find that by order dated so and so, this court directed payment of aforesaid amount of cost rupees on failing which to initiate a suo motu proceeding against the opposite party number 6. Finding that our order has been repeatedly violated, by order dated so and so, we proposed punishment of 6 months imprisonment for having committed contempt of this court and directed so and so to file show cause affidavit with regard to punishment. Instead of filing a show cause affidavit, the present application being miscase has been filed to recall public modification of the order dated so and so with regard to the quantum of trust. We therefore leaving open to the question of modification of the amount of the cost imposed direct so and so will appear before this court on so and so in person and file a show cause with regard to the punishment proposed. On that day, however, after considering the show cause, necessary orders will be passed with regard to the quantum of punishment. Okay, this was passed on 13/12/2013. Against that, okay, orders one from order of the Honorable Supreme Court produced by the Land Council kept on record of this matter after disposal of the SL. Okay, SLP order আসলে order dated আছে 11/12 flag S বার করলে
Flag is
Leave granted the appellant sir before this court assailing the order dated so in. Okay. The grievance essential in this application is in respect of certain adverse observation made by the High Court against the appellant, including certain direction to punish the appellant under the case of before the High Court and arising in a petition where the writ of habeas corpus had been sought alleging that Ms. Mandakini Jena, his daughter, was not being allowed to meet the writ petition as she was abducted. Direction was not to trace her in that circumstances, noting that the alleged detainee had married so issue of direction to trace her didn't arise, but High Court having noted this aspect of the matter was of opinion that marriage as facilitated by the appellant was not justified. It is in that circumstance certain adverse observation had been made by the High Court against the appellant, which had led to this appeal. During pendency of the appeal, an affidavit was shown by Mandakini Jena has been filed for the perusal of the same indicates that Mandakini Jena has shown an affidavit stating that she has voluntarily out of her own will married so and as in the date of marriage, both were majors. The date of birth as indicated as so. It is further stated in the affidavit that living happy married life and have 2 children, one from the wedlock, the parents are also reconciled. In that circumstances, in our opinion, when the parties themselves are indicating the manner in which their marriage between them had taken place, the reason for which the petition parties have sought the assistance of appellant, it would not be justified us to penalize the appellant for this, and therefore the order passed by the High Court to the extent of making adverse observation against the appellant, directing the criminal prosecution as also imposition of fine shall stand set aside. Allow or monitor the working of our organization. Okay, so then already no further order is necessary. It is already all right. In view of the order passed by the Honorable Supreme Court, at a date
11th October 2020.
11th October 2022 in लिखी दो ऊपर क्रिमिनल अपील नंबर 1 से ऊपर लिखा इसे ऑर्डर है ना लागे इस है ना no further order is required to be passed in this writ petition which is accordingly disposed of.
Published.
All the missed cases have also been disposed of. Yes. The parties are present or what? In this item, the parties are present in this. Item 12. Okay. Because there was a direction to the opposite party number 6 to.
Parties are present.
Yes, yes. In item 12, sir.
No, 11. We are. All right. Yes.
Item 12, Millard. I am for the petitioner, Millard. Millard, you kindly see the last order dated 24/8/2023.
Wait.
I am filing a compliance affidavit
What is this writ petition
My
for?
lord, I may be. This is here about, my lord, the father had not got any opportunity to see, though it is not a custodian on this.
No,
The
what is
case-
the prayer in this writ petition?
My prayer about the my lord is a habeas corpus.
Habeas corpus.
My lord.
Habeas corpus for what?
But the
Who
son,
has been detained?
that son was not able to access by virtue of my lord's direction time to time. It was passed. However, the son was accessed. The father, my lord, made the son, and in the meantime, the development has been taken place between husband and wife. And now they have taken the child to Pune for the my lord assessment in the autism, because for the welfare of the my lord was intervened only because to safeguard the future of the child. That's why my lord time and again this honorable court was pleased to direct the production of the child assessment purpose, and the wife was also present. Now the husband and wife both my lord altogether had gone to Pune as per the last undertaking, which was my lord was granted by my lord this honorable court, and smoothly they have undertaken the assessment before the my lord.
So what you have done, let us see
I have
that.
filed the affidavit, my lord. Kindly see.
Therapy will start.
Hmm?
Therapy will start.
The therapy has been started, and it has been advised by the.
What is the problem with
Item 13.
Item 13. It's a writ of habeas corpus. The petitioner's minor girl has been kidnapped since the month of March, my lord, and they have taken several adjournment for instruction, my lord, till that today's first status report.
what when the
My lord,
last
last status report we had received in August. Your lordship may grant.
the FIR dated is 3/3/23.
Yes, yes. Dated 3
You have
3
named the person.
Yes, yes. Accused person Gaurahari Swine. FIR named.
Okay.
FIR is.
Victim has not yet been rescued.
Yes, yes.
તે લોકો કુଆડે ગલા ସେ ઘર ફેરાર Mrs. Patnaik?
ये my lord Hyderabad पड़ीथिले in the meantime.
हाँ.
So team भी ଯାଇଥିଲେ Hyderabad, but till
Past,
date I think last information my lord August ମାସରେ ଆସିଥିଲା. Yesterday also I tried to contact. आ ଭିତରେ ଦି ଜଣ IAC change ହେଇଗଲେ, ଜଣେ retired କରିଗଲେଣି, ଜଣେ transfer ହେଇଗଲେଣି. So lordship may grant a short date.
କେବେ
Maybe
ରଖିବା କୁହନ୍ତୁ ଆଉ ସିଏ ତାଙ୍କ
maybe
the petitioner apprehends my
Day-
lord.
day after tomorrow,
She
sir.
might have been killed by the accused person. She apprehends.
ହାଇଦ୍ରାବାଦ ଯାଇଛନ୍ତି ପୁରା ବୁଲୁଛନ୍ତି ସିଆଡେ ଆଉ
Hyderabad ଯାଇଛନ୍ତି 4ଟା ଡେଟ୍ ଗଲାଣି ଆଜ୍ଞା. Your lordship have glanced towards past orders.
Mrs. Patnaik 9th ରେ ରଖୁଛୁ
Oh,
ଆଣନ୍ତୁ
yes.
the Mrs. Patnaik and additional government advocate submit that she may be given some further time to obtain up-to-date instruction in the matter. List this matter will be commencing from 9th October 2023. Yes.
Item 14.
Last occasion, your lordship directed to file a guardian word case. I have filed that and give the number.
What is that? This one we have. What is this matter, Mr. Patnaik?
My lord, this habeas corpus, but your lordship expressed your opinion that habeas corpus will not lie.
ଟିକେ mic adjust କର
Yes, sir.
yes
We may.
yes କଣ ହେଲା
This is habeas corpus petition, but last occasion your lordship said that against the natural father, we can't file any habeas corpus will lie. You filed a case before the proper court. I have
ଓ the ହଁ ମାନେ କି କାହାର କଷ୍ଟଡି ପାଇଁ ଇଏ କରୁଛନ୍ତି
child.
ଅଜା ମାଗୁଛନ୍ତି କଷ୍ଟଡି ଛୁଆର ନାତିର because
Oh,
after the death of the mother
you have already approved the family court
Yes. No, not family court. This is discharge court.
acha discharge court a petition so if this matter has already been taken up for because
No,
notice
no,
has
no.
to
This is already filed. Your lordship say the filed and give the number.
Previous occasion, your lordship was of the opinion that this matter may be directed to be disposed of with a limited time because the child also suffers from
no,
autism.
The problem is that we do not know that we can fix now the date of service of notice because
Your lordship, in the spirit of
direct to appear both the parties.
in the spirit of urgency, your lordship, I'll appear if they serve a copy on me.
What is the date, Mr. Patnaik? Is it?
Sir, I don't know actually.
Acha, you appear on the next date, both of you. Then we are
Your
passing
lordship,
the order.
the only concern is there was an interim arrangement of this court wide order dated 18/7/2023. Your lordship may have a look at that order. In that order, 18/7/2023 of this court, your lordship.
Okay, what is that arrangement?
In that order, it was directed that whenever the petitioner wants to visit the child, then he may be allowed to do the same, or the opposite party number one will take the child.
This is not interim arrangement. This is a convenience.
Your lordship, the only
Because they have not shown us that.
Petitioner ମାନେ କିଏ ଜେଜେ
Yes,
father-in-law.
Father-in-law.
ଓ ଆଚ୍ଛା ମାନେ ପିଲାର ହେଲାନି କି ସେ ପିଲାର ହବ କଣ
ପିଲାର ଅଜା ହେଲା
ଅଜା ହବ
ଅଜା
ଅଜା ନାତି ଦେଖା କରିବ କଣ ଅସୁବିଧା କଣ ହଉଛି କଣ
that arrangement may be allowed to continue, your lordship, with the
Patnaik
because they have filed a case against the father-in-law.
ଆପଣ ପ୍ରେଜେନ୍ସ ରେ ଯିବ ଗୋଟେ କି ଆଚ୍ଛା କଥା ଅଜାଟା ନାତି
Your lordship, no case has been filed.
My lord, he has filed a case against the father-in-law before the police station. This police station, my lord, already filed a case.
It's all right. That arrangement should continue and please assist him so that we are passing the order for early.
Your lordship direct to appear them in particular
right,
date.
Yes. No, the next date, he will ascertain the next date when this particular case has been fixed. The London Council says that you will appear and then we are directing from the date of appearance within 6 months that is to be disposed of.
Yes, ma'am.
All right. And
Do you know the date? Next date.
Lordship, they served only a copy today. Your lordship, I have just one concern which I want to highlight, my lord.
Yeah.
In that arrangement, let me first clarify that no such case has been filed by us. In their petition, your lordship, the only concern is in that interim arrangement, there was a specific observation in no event the custody of the child is to be taken away from the father. We apprehend because here
whatever arrangements are there, we are not going to dilute that.
No, later.
But that is the domain of the trial court, my lord.
Mr. Till the London trial court passes any order, that arrangement should continue. That
your lordship may make that observation. That is my only preference.
All right. The Mr. Kalyan Patnaik, London senior advocate, appearing for the petitioner, filed a memo indicating therein that GUA.P. number 22 of 2023 bracket लिख दूं तो Ravindra Kumar Patnaik versus A. Harihar Prasad and another has already been filed before the London District Judge Bhubaneswar. The memo is taken on record. The London Council appearing for the opposite party submits that the opposite party will appear in the said case on the next date itself.
Why don't you, your lordship, fix the date? On that day, he will appear.
I'm ସେଇଥିପାଇଁ ପଚାରୁଥିଲି ଆପଣ କେବେ ଡେଟ୍ ଆପଣ ତ କହୁନାହାନ୍ତି ନେକ୍ସଟ ଡେଟ୍ ଯୋଉ ଦିନ ହବ ଆପଣ ଯଦି ବୁଝିକିନି କହିପାରିବେ ଆପଣ ଯଦି ଦେଇଦେବେ ଆମ ସେଟାକୁ ଇନସର୍ଟ କରିଦବୁ ଆପଣ ଲୋକାଲ କାଉନସିଲ ଯଦି କିଏ ଥିବ
by lunch I will intimate you,
which is fixed to so and so. The land council for the opposite party submit that will ensure the appearance of the opposite parties in the next date. both the parties shall cooperate with the learned districts for early adjudication of the proceeding, considering the submission made by the land council for the respective parties. This WPCRL is disposed of with the direction to the Land District Judge Bhubaneswar to expedite the proceeding in so and make every endeavor conclude the same within a period of 6 months from the date of appearance of the opposite parties. The interim arrangement passed by this court as per order dated 16/8/2023 shall continue until further order is passed by the Land District Judge Bhubaneswar in that respect. WPCRL is disposed of. Yes,
Your Lordship,
order copy we communicated to the Land District Judge Bhubaneswar.
Your Lordship, the interim arrangement wide order dated 18/7.
18/7, yes. All right, 18/7/2020 shall continue.
Much obliged, Your Lordship.
Yeah.
Item number 15.
My lord. My lord, the minor daughter of the petitioner is kidnapped by the accused person, my lord. But till date, the opposite party number 4 has not yet been rescued till yet.
So what is your prayer for rescue of the minor daughter?
My lord.
You have lost the
Yes, my
FIR.
lord. FIR. Once
FIR is annexure.
Annexure 2, my lord.
You have named the person who has taken your
Yes,
daughter.
my lord. Yes, my lord.
May I, my lord? Last order, my lord, you have to file an affidavit, my lord.
What affidavit?
I have to file an affidavit in the status report, my lord. Kindly taken up tomorrow or day after tomorrow because.
Okay. Day after tomorrow, no. এটা ସେ ୱିକଲି ଲିଷ୍ଟରୁ ଡାକିବେ ତ ଏଟା ଡକାଯିବ ଆମର 27 ତାରିଖ ଦିନ 20 27/9/2023. Okay. Yes, my lord.
Item number 16.
Yeah, clear, lords. My lord, the minor daughter of the present petitioner not rescued till date, my lord.
Any FIR has been lost?
Yes.
Name the person, Manoranjan Biswar.
Manoranjan Biswar.
Last time we directed to file an affidavit. Now we have traced out the
victim girl has been traced out.
He has not rescued, my lord, but that is, my lord, para 5, my lord.
Para 5.
Located. Located, not rescued.
But they are now at Bangalore, my lord, some area of Bangalore. So the team has already been ready to go, my lord, already proceeded, my lord. So let me give some time.
Okay, is residing at so and so Bangalore in the state of Karnataka now after so and so. Team is ready to proceed to so and so. Okay. Have you given a copy to the?
No,
give a copy.
Well,
I'll give my. So we are adjourning this case because they are taking steps now. The victim has already been located, victim and accused, right? So Land Council for the state has filed an affidavit of the inspector in charge of Simulia police station, wherein in paragraph number 5, it is stated that the victim and the accused are residing in so-and-so and with the approval of the Superintendent of Police Baleswar, a team is ready to proceed to that place within a short period to rescue the victim as well as to apprehend the accused. The affidavit filed by the opposite party number 3 is taken on record. Let a copy of the affidavit be handed over to the learned counsel for the petitioner during course of the day. The learned counsel for the state seeks some more time to apprise this court about the result of the team's visit to Bangalore. Please, this matter छुट्टी पूर्वରୁ रखिवा तो 16th ରେ ରଖି ଦଉଛୁ Please, this matter on 16th October 2023 the learned counsel for the state
17 October 17
17
17
17 October 2023 the learned counsel for the state shall produce the up-to-date instruction in the matter. Free copy of the order be handed over to the learned counsel for the state. Yes, Mr. Patnaik, what do you say?
3rd October.
Yeah.
Yes, it fixed to 3rd October.
3rd October. ए लिखी दियो. तो जो आप पूर्व मैटर है ये कह दो. All right.
Item 17.
Item 17, I may prohibited on behalf of Mr. B. Tripathi. FIR registered on 6/6/23. Still that Kal is major, 21 years, but not rescued from the opposite party by 5. OP5.
We have those with the measure. We have taken steps. The police team had gone to Andhra Pradesh, and also then after that in August to Chennai, my lords.
ପିଲା ନାଁ ଦିଆଯାଇଛି
ପିଲା ନା ଦେଇଛି ତମେ ଝିଅ ବି ମେସେଜ ଦେଇକି ଯାଇଛି ଘରେ ଯେ ମୁଁ ଆ ସାଙ୍ଗରେ ଯାଉଛି ମତେ ଖୋଜିବନି.
previous
That
occasion
is the FIR. That is there in the father's FIR.
wrongful detention କଣ ଏଇଟା ହେଲା?
previous occasion ବି ସେ ଯାଇଥିଲେ undertaking ଦେଇଥିଲେ
ମୁଁ ସୁବ୍ରତ ଖାଡେଙ୍ଗା ସହିତ ଘର ଛାଡି ଚାଲି ଯାଉଛି ମତେ ଖୋଜିବ ନାହିଁ.
ତାହେଲେ ତ
ଲେଖୁନାହାନ୍ତି ଆପଣ ଯେ ମାରେ ତୁ ଫେରି ଆମେ ବାହାଘର କରିଦବୁ ଶାନ୍ତିରେ ରହିବୁ କାହିଁ କୁଆଡେ ବୁଲୁଛୁ ତାହେଲେ ଆପଣ ତାକୁ କନଭିନ୍ସ କରେଇବେ ନା ସେ ଆପ୍ରିଏଣ୍ଡ କରୁଛି ଇଆଡେ କେସ୍ ଫେସ୍ ହେଇଯିବ ଆରେ କେସ୍ ତ ହେଇସାରିଲାଣି
previous
ଆରେଷ୍ଟ
occasion
ହେଇଯିବ ଆଉ କଣ
ନେଇଥିଲେ undertaking ଦେଇଥିଲା ମୁଁ ସେମିତି କାମ repeatedly ଆଉ କରିବିନି ଆଉ
କିଏ
ସେ OP5
ଗଲାଣି ତ ଆଉ ସେ ସେ
Same
ଯାଇକି
again.
ଆନନ୍ଦରେ ରହିଛି ସିଏ ତାର ସ୍ୱାମୀ ସାଙ୍ଗରେ ବାପା ହେଇଯିବଣି ମେଜର ଥିଲା ତେଣୁ କାହିଁକି ଡିଷ୍ଟର୍ବ କରଉଛନ୍ତି ତାକୁ
ଇଲିଗାଲ ଡିଟେନସନ ତ ନାହିଁ ନା
repetition either are scope jo wrongful detention illegal detention where is that when a major girl on her own volition leaving the note before her parents that I am going on my own volition I am going with him and don't search for me he is now staying with this opposite party number 5 leading a life maybe conjugal life or whatever it may be. So, what is the question of entertaining this writ petition for habeas corpus?
in the FIR you yourself say that
And ଲକ୍ଷେ ଟଙ୍କା ସୁନା ଗହଣା
ତୁମ ନେଇକି
ସେଇଠି
ପଳେଇ ତାର କଣ କରିବ
that is there in there.
ଗୋଟେ instruction
Instruction
ପଚାରିଦେବି ଟିକେ
on instruction on the thing
Instruction she has received already.
କିଛି ସୁନା ଅଳଙ୍କାର ଯାହାକି ତାର ବିବାହ ନିମନ୍ତେ ହୋଇଥିଲା ତାକୁ ସାଙ୍ଗରେ ଧରି କେଉଁଆଡେ ଚାଲି ଯାଇଛି ତାପରେ ମେସେଜ କଥା ଆସିଛି.
The had the land and council for the petition land council for the state. This WPCRL has been filed with a prayer to rescue the daughter of the petitioner, which is at about 21 years, and to produce before this court. The land council for the state drew the attention of this court to the first information report lodged by the petitioner before the police station eta FIR registered ହେଇସାରିଲାଣି କି ହଁ before the Bharatpur police station on the basis of which Bharatpur PS case number.
MMR है sir.
Missing report.
Missing person register.
And in that report, it is mentioned by the petitioner that the while leaving the house, he has message ଦେଇଥିଲା ପରା
ଗଲାକୁ ନେଇକି ଯାଇଛି ବୋଲି କହିଛନ୍ତି ପଇସା ଆଉ ସୁନାଗହଣା ନେଇକି ଯାଇଛି ତାପରେ ମେସେଜ ଆସିଛି
while leaving the house, he has taken a cash of rupees 1 lakh and gold ornaments and left a message on her mobile that she is leaving the house on her own accord with the opposite party number 5, and that the family members should not search for her. The land council for the petitioner state submits that he has received the instruction
instruction ନେଇଛି regarding the steps taken जोथरा में CIG publication ହେଇଛି enquiry ହେଇଛି different दीटा जगह को ଯାଇଛି
कोन आछन देखि त उठे लिखि दवा त दियन सेटा रिपोर्ट Land Council for the state has obtained instruction from the IIC of Bharatpur police station, wherein it is indicated that what steps have been taken to trace out the missing girl, and but no positive result has been found out. It is further mentioned that the inquiring officer is taking all the sincere steps to trace out the missing girls. In view of the available material on record and the report furnished by the Land Council for the state, we find that it is a case of missing person, and in view of the ratio laid down in case of so and so, the writ petition is not maintainable, particularly when the daughter of the petitioner on her who is a major girl on her own accord has left her lawful guardianship with the cash and gold ornaments, and left a message that she is accompanying opposite party number 2, and therefore at this juncture it cannot be said that there was any kind of wrongful detention of the daughter of the petitioner. Accordingly, this writ petition is disposed of. এটা গোটে দেখি ଦେଇକିନି ତାପରେ ଏଇଟା ଗୋଟେ କପି ରଖିଦେବେ, ଏଇଟା ଗୋଟେ କପି ରଖିଦେବେ ନା ସେ ଡିସିସନ ଗୁଡାକ ଲେଖିଦବ ସେ ଯୋଉ ମିସିଂ ପର୍ସନ ର ଏଇଟା
Item 18.
May I please, Your Lordship? Item 18, my lord, the matter is pending before the mediation, my lord, and the last date is fixed for 5th October, my lord.
What is this matter for?
Matter for, my lord, the habeas corpus, suit of habeas corpus. Because of my wife and my daughter are in the illegal custody of my father-in-law and mother-in-law, and for the purpose of education of my child, I filed this petition, my lord.
ଝିଅ ବର୍ତ୍ତମାନ ତା ବାପା ମା ପାଖରେ ରହୁଛି, ଏଇଆ ତ? ସେଟା ଇଲିଗାଲ ଡିଟେନସନ କେମିତି ହବ?
Because my wife is interested to come back, and due to the inception of the party opposite partner 1 and 2, father-in-law, mother-in-law,
file କଲେନି ଆପଣ appropriate petition appropriate court ରେ?
This court is directed, my lord, for mediation. The mediation going on, my lord. My party opposite party number 3 also come with his son, my lord, and the matter is going on here.
Who has entered appearance for the other
yes
side?
Mr. Behra is also appear, my lord. Today is not here, perhaps. Joydev Behra is enter appear. Each occasion in the mediation center he is appearing.
Okay, now
including the wife, my lord.
What is the date fixed?
5 October, my lord. Your lordship may fix this matter on 12 October or 19 October.
The mediation is going on.
Going on, my lord. Yes.
Parties are also appearing.
Parties are appearing, my lord. Both the parties are appearing.
The land counsel for the land counsel for the petitioner drew the attention of this court to the order dated 28/7/23, 28/7/23, and submitted that as per the order of this court, the mediation is going on, and the parties are also appearing in the mediation center, and the next date of mediation is fixed to
5th October, my lord.
5th October 2023, and the matter may be taken up
12th,
in the week commencing
Possible.
from 16th of October 2023. Please, this matter will be commencing from 16th October 2023. Yes.
Deeply obliged.
Item 19.
May it please me. My lord, I am for the petitioner, and this matter is nature of habeas corpus. In the meantime, the local police has rescued to the victim minor girl of the petitioner, my lord.
Handed over to
Hand over
you.
to me. Hand over to him.
She is now staying with you.
Yes, my lord.
You are the father.
Yes, my lord.
You
Yes,
see the instruction.
reporter the last victim girl was rescued. Tamil Nadu. The statement of the victim has been recorded in Assumption, and the victim to DHS medical exemption. The victim was produced before the SDGM Bhadra. Her statement was recorded 164. Victim understood denied about the kidnapping by anybody as well as any sexual assault. Victim was also produced by CWC sent to Childline Bhadra. Presently, the victim is staying with the present. The Land Council for the state has produced the written instruction dated 29/8/2023 received from the IIC of Bhadrak Rural Police Station, wherein it is stated that the victim, who is the daughter of the petitioner, has been rescued, and her statement has been recorded by the investigating officers, also by the Land SDGM Bhadrak under section 164 CRPC. And the victim denied about the kidnapping by anybody as well as any sexual assault, and she was produced before CWC Bhadrak and sent to Childline Bhadrak, and at present the victim is staying with her parents. The Land Council for the petitioner also submits that the daughter of the petitioner is now staying with in the house of the petitioner. In view of such submission made by the Land Council for the respective parties and the report furnished by the IIC so and so, the writ petition is disposed of. Copy voter रख देवे,
Obligement.
हाँ? आगे ये रखो।
Item 20.
Item 20, my lord. FIR registered on 3/7/2023. Still not record the minor girl from OP5.
Who is the petitioner?
Petitioner brother.
No. Who has been petitioner sister? Achha.
Sister, my lord.
Minor.
Okay. You have lodged an FIR.
FIR, my lord. Annex 1.
and given the names of those persons who have Akash Jena. The other two are the family, that parents.
Parents.
कौन ଆସିଲା report?
ହେଲେ ପୁନା ବି ଯାଇଥିଲେ ସର୍ଚ୍ଚ କରିବା ପାଇଁ ପାଇନାହାନ୍ତି
ପାଇଲେନି?
ନା they trying manage for more time.
Father of the victim girl, after due analysis of the CDR and IME search, it is ascertained that the tower location of the said mobile number is Pune under the state of Maharashtra. After taking prior permission, the IO along with the father of the victim went to Pune and conducted raid at Pune with the help of so police station on such as to trace out the victim, but the alleged accused and the victim have absconded from the locality evading police action. After that, we tried to trace out the victim through local sources, tracking of the location, but no fruitful result received so far.
What is the document you have filed to show that she is a minor?
Document to that effect is not filed, but mentioned in FIR only lost to. But
Date of birth.
Have you
date of birth
mentioned anywhere
no
that
certificate
your
is
sister
there?
was ଆପଣ
Comes-
mention କରିଛନ୍ତି ଯେ ଆପଣଙ୍କର ଭଉଣୀ minor ବୋଲି କୋଉଠି restriction ରେ
minor ବୋଲି ଲେଖା ହେଇଛି।
ନା ସେଇଟା ଦରକାର ନାହିଁ ଲେଖିବା।
No, it's necessary. Certificate ଅଛି board of secondary education ନା only
ସେଇଟା ଆପଣ ନିଜ ପାଖରେ ରଖିଛନ୍ତି ନା?
annex କରିଛନ୍ତି ମାଇଲର
କୋଉଠି?
page number 16
ଆଚ୍ଛା 1-3-2007 ଆଚ୍ଛା 7 ହେଲେ ଓକେ 16 ବର୍ଷ ହଉଛି 16 ବର୍ଷ କମ୍ପ୍ଲିଟ କରି 17 ବର୍ଷ ଚାଲିଛି। ଆଉ କିଛି ସମୟ ଦରକାର ନାଇଁ ଖୋଜାଖୋଜି କରୁଛନ୍ତି ନା ଖାଲି ବୁଲିକିନି ପଳେଇ ଆଉଛନ୍ତି ପୁନା
ଯାଇଛନ୍ତି
ତାପରେ କହିବେ ତାମିଲନାଡୁ ପୁଣି ଯାଇ ବୁଲି ପଳେଇ ଆସିବେ।
ତାପରେ some of the
ଯିବାଟା ଆମେ ମନା କରୁନୁ ଯାଇକିନି କିଛି କାମ କରିବା ଦରକାର ନହେଲେ ହୋଟେଲରେ ରହି ବୁଲି ବାଲି ଦେଇ ପଳେଇ ଆସିବେ ସରକାରୀ ପଇସାରେ ସେଇଟା
I was talking with the IC yesterday, my lord. He was telling one of the relative of the the accused, he is a lawyer and he is trying to pacify them.
Trying to?
Pacify them.
ଟିକେ ଏଜଟା ହେଇନି ତ ତେଣୁ ଉଚିତ ହେବେ ଏଜ ହେଲେ ସେଇଥିପାଇଁ ଭୟ କରୁଥିଲେ। ଦେଖନ୍ତୁ the Learned Council for the state has produced the report dated 24/9/2023 of IIC Jaleshwar police station, from which it appears the written report is taken on record. Land Council for the state seeks some further time to obtain instruction in the matter. केवे रखियो कौन तो था?
9th.
All right. Now 16th में जाओ. 16th October 2020. Yes. Yeah.
Item 21.
April. The nature of habeas corpus, my lord.
Yes.
Last occasion, lordship directed to obtain instruction
for production of the niece of the petitioner who has been missing since so and so. On the basis of the report, missing report was registered. Your representation are submitted. The petitioner direct in the office to recover. Rajesh, direct the opposite party number 3 in particular to submit a status report. And
My lord, he is a major girl and she has sent a letter by registered post that she has already married. The joint affidavit also he has filed. And
police station
I see Chandra.
ना ए नोटारी पुणी आसिलानी नोटारी मैरिज सर्टिफिकेट सब
तापर से आसिकी भी appear with that letter is also there, madam, what she had said. Second page, your lordship.
सेकंड पेज ए जेटा से वेरीफाई करियो आपण तम कॉपी दियंतु एटा ताको झियोर लेखा की काहा लेखा से जानि परिबे
देबे हमर सीडी रे भी एंट्री भी ही जाई that is the
if they are already both of them are major and they marriage notary छाडंतु से जदी आसीबे मैरिज रजिस्ट्रेशन करिवे appropriate authority पाखरे then there is no problem. So
What is your instruction? Have they
My,
made it?
my instruction is if she is actually married, then if they both of them can stay happily, we have no objection to that. But we have not seen here her since last.
आपण ए जो से दउचंदी आज जो चिट्ठीटा आपनकर झियो लिखिची आईआईसी को एड्रेस करी आ से जो फोटो जॉइंट फोटोग्राफ सहित
Once he comes and says that, then we have no objection to that marriage.
आगे एटा गुटे वेरीफाई कर दियंतु आ ता भीतर से तो कहउचंती देखुचंती बेली एटा you hand over a copy of the Land Council for the state has produced the written instruction dated 24/9/2023 from IAC of Chandaka Police Station, wherein it is mentioned that on 5/9/2023, one registered post was received in the name of IIC Chandaka Police Station, wherein one written application along with 2 sets of Xerox copy of document relating to marriage between the Yujamon sister na
Niece.
between the niece of the petitioner and one Pradeep Kumar Jena finds place and the documents are taken on record. Let the Land Council for the state serve the copy of the application, written application, as well as the documents in connection with marriage to the Land Council for the petitioner during course of the day. The Land Council for the state seeks some further time to obtain the up-to-date instruction in the matter. When submit that it is not disputed that the victim is a major girl, and he seeks some time to obtain answer. Raise this matter in the week commencing from 16th October 2023. The written instruction is
ଚିଠିଟା ବି
taken.
ଆସିଛି ସେଥିରେ ଲାଷ୍ଟ ପାରାରେ ବି ଲେଖିଛନ୍ତି that he has communicated the same to the uncle and the father.
That should not.
I will give it.
Not common.
Item 22.
No, direct to Swan. No. May I please, in between the minor sister has been already rescued by the police.
Rescued.
Yes, the Land Council for the state has produced the written instruction dated 22/9/2023, received from Inspector in charge of Pipli Police Station, wherein it is mentioned that the victim girl, who is the sister, sister of the petitioner, was rescued on 16/9/2023, and she was sent for medical examination, produced before the court, and her statement under section 164 CRPC was recorded. आदि तो किछि लेखा ही काहा को हैंड ओवर कराला बेली
लिखा है
कोन आपन instruction
the parents
and it has already been the victim girl has been handed over to the
parents,
to her parents. The land counsel for the petitioner submits that he has received instruction from the petitioner that the victim girl has now returned back home, and she is staying with her parents. In view of such submission, the writ petition was disposed of. Public.
Item number 23.
May I please? Last occasion. Ashiki.
23.
My lord.
23 to 140 years. Yes.
My lord. Your lordship last occasion directed the state council to take instruction about the victim, my lord.
My lord. In this case, sir, I have also talked with the ISC, my lord, that the father of the accused also been called from Kerala. He was in Kerala, he was summoned and he has been called for. Yesterday or day before yesterday, there was a meeting including the father of the victim, father of the accused, and the servant. So they have said that within 7 days they will.
So what is the age of the victim?
Mind
My lord, 15 years.
Yes. And
How
he
she gone?
played away with a relative. Relative sign for it.
Marriage तो possible no,
No, possible no. Within 7 days they will produce. That is why he is written in para 7. You know, para 7 of the
7. Discuss with the swans of swan presence of local sarpanch and other try to rescue the victim. Copy the land council for the state has received written instruction dated 23/9/2023 from IAC Other Police Station, Niagara, wherein it is stated inter alia that all sincere steps have been taken to trace out the minor daughter, as here minor daughter of the petitioner, as well as apprehension of the accused, and there has been discussion with the father of the victim and father of the accused in presence of the local sarpanch and other village entries, and the minor victim girl is likely to be rescued within a period of 7 days. Stop. The land council for the state submitted that the victim girl is related to the accused, and she is minor, and may be given some time to obtain up-to-date instruction in the matter. Let a copy of the written instruction obtained by the land council for the state be supplied to the land council for the petitioner during course of the day. List this matter in the week commencing say 16th of Swan. Yes. Also, Please, yes.
Item number 24.
Yeah, the present petitioner, the minor girl of the present
ये
petitioner.
माइक को ठीक से यूज करो तू
Minor girl not rescue till date, my lord.
एफआईआर ना देइथिले
Yes, my lord.
कान्हू चरण जेना
Kanucharan Jana, principal.
डेट ऑफ बर्थ केते आसिला
Your lordship can annex it to date of birth
माने 17 वर्ष हो गला
26
17 वर्ष हो केते मास
6 2006.
26/6/2006.
2006.
para 5 IO has collected mobile number of so and so CDR location of the concern came to light that so and so is functioning who jaga heta South Goa
हाँ
और सो पड़ी जाउ गुंदी South Goa is so and so PSK
some area of South Goa
हाँ
there are two cases my lord another case my lord also both the accused person was near that South Goa so one IO they went to there
माने दी जण सांग दीटा झियो को नै किनी जाई छन
so in one case they was rescued but another this present case not able to rescue my lord they switched up the mobile and the exact location could not be found out thereafter my lord
गोवा जाइथिले अपन टीम
आगे
कोन हला
गोरे फेरी के आसु दी आगो एठी गलु जोटा जो प्रेजेंट पिटिशनर स्पेस my lord सेठी एनक्वायरी कलु से एरिया रे ता पाइलुन ता मोबाइल स्विच अप ला कोन ता टावर में एग्जैक्ट लोकेशन जानि पेलुनी बट somehow this second जो आर केस रो से माने रेस्क्यू हेले एवं अपेंड कर देते ताको मोबाइल ता ऑन थिला सो रेस्क्यूड दैट so again we are trying also but some time may be given
देखो तार से किसी न करते यदि से गोवा बुली कि नाचथिबो ताले बड़ा असुविधा करता तो please see that it doing something okay madam the Learning Council for the state has produced written instruction received from IIC Basta police station dated 23/9/2023 that after receipt of the CDR and location of the mobile the police team went to South Goa to locate the victim as well as the accused, but couldn't rescue her or arrest the accused as the mobile phone was switched off. And it is further stated that sincere steps are taken for rescue of the minor girl. At an early date, Land Council for the written instruction is taken on record. Tangude copy diyontu. Let a copy of the written instruction be supplied to the Land Council for this day. 6 some time. This
17.
matter. 16 तारीख को दो
17, my lord.
17th of October 2020.
17.
Yes. Appellant. The IAC of the concerned police station will serve a notice upon the appellant requiring him to remain present on the he bail achi?
Yes, madam.
On the next date and also in the meantime engage another counsel to appear on his behalf. Meanwhile, so and so last and lot so asile se appear to yada agu gasun कौन आपन ना कौन please use the mic properly
Uppad ko bench.
ଆପଣ advocate ନିଜେ ଦେବେ ନା ଆମ legal aid ତରଫରୁ advocate engage କରାଯିବ
Sir ko bench.
ସାରଙ୍କୁ ଦେବେ वकालतनामा दे दीजिए फाइल करो in pursuance of the order dated 4/7/2023 से तांगर आइडेंटिटी कार्ड की कौन गोटा आनी थी आधार कार्ड वाला किसी अच्छी देखिले ना बे the identity proof
xerox आनिचंती
हाँ सेटा दे दंजे the appellant is present and produce the other copy of the Aadhaar card which is taken on record. अपन टिके ताको identify करे दो एरा कौन को भाषा रे लेक्चर दिए एरा कौन
तेलुगु भाषा रे
हाँ तेलुगु रे अच्छा the is Mr. Pulakes Mahanti, Land Council, files wakalatnama for the appellant.
Signatures आपका ये
which is taken on record. The name of Mr. newly engaged counsel be reflected in the cause list in place of J. Katkia and his associates. एरा कौन ये समस्ते कौन जे कटकिया करो एसोसिएट ना अन्यान्य तापर आउरी पस्तिले अच्छा
आगुरु थिले
except the name of Mr. Pulakes Mahanti, the name of other counsel shall not be reflected in the cause list henceforth. एडा जदि पड़ी जीवो तो ए वीक रे हमें टेक अप कर दो खाली आज ऑर्डर टा ही जाउची but it remains in the weekly. You get yourself prepared. We'll argue
paper book
भाई ना दी अच्छा ठीक है this matter in the week commencing from और सप्ताह टाला 3 तारीख ना 3rd October 2023. Copy of the paper book be handed over to the Mr. Mahanti in court today. अरे दाउटू signature नेकिन देगा आपण वकील बाबू को नुआ वकील बाबू एंगेज करा गला तांको पेपर बुक दिया गला आसंदा सप्ताह रे सुनानी हो आपनकर केस हला तेणु वकील बाबू को जाई किनी देखा करी से केस विषय रे जहा इंस्ट्रक्शन दबा कथा सब दियंतु हला हां काली अब सप्लीमेंटरी से डब्ल्यूपीसीआर लानी बनी अच्छी जिन
of a weekly list, my lord.
208 it's for some defects are there.
My lord, already removed by me. And copy not served. Just I filed. Just I.
What is the conviction and what is the sentence?
My lord, conviction under section 323, simple imprisonment for 2 months, and 332, simple imprisonment for 2 months, and 427, simple imprisonment for 2 months, and which is run consecutively, my lord.
You were on bail during trial.
My lord.
What is that item number?
Item number 208 of this weekly list, my lord.
You have filed bail application.
My lord.
All right, admit bail granted.
Much obliged. Just pass copy to the state, my lord.
Yes.
Conviction matter for bail, my lord.
Much obliged.
My lord, item number 207, my lord. This is the 3 SC/ST appeal, my lord.
Notices to go.
Notice will go.
All right, extra copy of the appeal memo be served along with all the annexures on the land council for the state, which will be sent to IIC of so and so police station. Case diary be obtained and report about service of notice on the informant. Matter to be listed 9th October 20.
Item 45, my lord.
Just a minute. Yes.
Item 45, my lord. 45, 3 SCST, nature of bail, my lord.
My lord, item. Wait, why are you in a hurry? I'm not going away. 45 कौन था पहले?
3 nature of bail, madam.
Same
Extra.
order. Issue notice कर दियो उनको. Extra copy to be served. CDCA and written instruction for service of notice. Yes.
My lord, weekly list item 234, my lord. I have filed I for interim bail, my lord. Last occasion, lordship directed to the State Council for obtaining instruction, my lord. Kindly take up, my lord.
Okay, okay, please.
My lord.
Yes.
Last petition mentioned that Pulinda is suffering from cancer, Lordship had directed for the instructions.
Item number is the bar
290. 2190.
कि देखिए कौन है इंस्ट्रक्शन नहीं चाहिए यदि आइटम नंबर 219 फाइल टा आनो तो देखो यस नेक्स्ट.
Pardon to mention, your lordships. I have filed an IF for extension of time of interim bail. My lords, my date of surrender is on 29/9/2023.
Pardon to mention, your
Lordship may kindly be taken up any day before 29.
Pardon to mention, lordship, a 2018 criminal appeal matter for final hearing may be taken up for final hearing.
2018 as per you पूर्ण appeal सब रोइची.
The paperwork is also ready, lordship.
ये पूजा छुट्टी परे मेंशन.
Yeah. Obliged.
Adjourned to 25th at 3:30 p.m. Matter is not listed. My senior was
कौन देखियो कौन.
mentioning the matter at 3:30.
All right.
Pardon for mentioning, your lordship. This is an application seeking correction of a typographical error mistake in order passed by this honorable court. The name of the appellant petitioner has been wrongly put as through.
Give the memo to.
I may pattern to
I
mention.
pray for the listing of this matter tomorrow, your lordship. The trial court has released him on bail up to today. That's why it's an urgency, your lordship.
Yes.
I may pardon to mention, my lord. Item 159. That is the SC/ST bail, my lord. Notice required. 159, my lord.
Notice you होता.
My lord.
First time as चीज़.
First time is.
All right. Issue notice. Extra copy to be served. CDCA. In instruction of service of notice.
Item 210, my lord. It's a criminal appeal against conviction. Out of 10 years, my lord, they're in custody for about 9 years.
Which item?
210.
110.
Lordship, my lord. NDBS Act, my lord, out of 10 years, more than about 9 years, they are in custody. I have filed a bail application for appellant number 4, the 2238 of 2023, my lord. My humble submission, let the State Council obtain the custody report, my lord, that
All right. IA number.
2238.
210. IA number 2238 of 2023. This is an application for bail of appellant number 4. Mr. Tripathi, Land Counsel, appearing for the appellant number 4, submits that out of 10 years of substantive sentence imposed by the Land Trial Court, the petitioner has already undergone 9 years of sentence.
About 9 years, madam.
About 9 years of sentence. Let the Land Counsel for the state obtain the custody certificate of appellant number 4.
They are in Malkangiri jail, madam.
From Superintendent of Malkangiri jail. Item number 210. से आईए नंबर होची 2238 of 2023 appellant number 4 रो ता नाटा लिखि देबे
विश्वजित राय.
हां से तारी कस्टडी सर्टिफिकेट ता मगांतु हैना 10 वर्ष को 9 वर्ष रहिलान. यस.
Item 15, my lord. In this case, I have already submitted the surrender certificate, my lord, on 24/8/2023, my lord. But there is noting, my lord, surrender certificate not filed, my lord. Kindly.
Surrender certificate ता लागी है नहीं देले फाइल डाल 15 नंबर 15. लास्ट आड़ देखो केबे फाइल करले
24/8/2023.
all right 15 रे लिख दियंतु the land and council for the appellant submits that after availing the interim bail period the appellant has surrendered. John a single appellant though
Mile.
and he has filed the surrender certificate on 24/8/2023. Let the registry place the surrender certificate on record. Yes.
Obliged.
I beg item 249 of the weekly list. Versus the appellant filed this appeal under section conviction under section 370
number
249.
कौन हला
Conviction under section 376 AB, Lordship. Imprisonment up to 20 years, Lordship. There is I file an IA for condonation of delay. That is 16 days delay, Lordship.
Notice has to be issued.
Lordship.
IA number so and so. There is an application for condonation of delay. Since one of the offenses under section 376 AB of the Indian Penal Code. Let an extra copy of the interim application be served on the Land and Council for
Just I am serving.
Served on the Land Council for the state. Will be sent to the IAC of Odgaon Police Station for the service on the informant. Leave this matter in the week commencing from 9th October 2023. Objection, if any, to the delay condonation application be filed. In the meantime, Land Council for the state shall produce written instruction about the service of notice on the informant. Free copy of the order be handed over to the Land Council for the state.
Pardon to mention, Your Lordships.
Yeah.
Lordship, item number 44 and 202, they are both STSC bails, my lord. So 44 and 202. Bail under STSC Prevention of Atrocities Act, my lord. Hence notice is to go.
44, okay. 44 is CRLA number 764 of 2023.
Lordship, please. Yes, ma'am.
Okay. One of the offenses 3 SCST Act issue notice extra copy to be served on the Land and Council for the state by tomorrow. CDCA and written instruction about the service of notice on the informant. Yes.
As well as 202, my lord. Same offense, Lordship. Same case, in fact, same FIR. All the villagers have been entangled.
202 same order.
Lordship.
Extra copy notice CDCA. Release this matter along with further message item
Yes.
number 44 single.
44. Grateful. Grateful.
My lord, I have a mention, please. CRLA 260 of 20, my lord. And already 6 years, 8 months have passed. This matter for bail was posted to 13th January 23, my lord, in the order dated 7th December 2022.
It has not been listed. You want to list it this matter?
My lord, 6 years, 7 months already.
What is the number CRLA?
My lord, 260 of 2020.
Already it will be listed tomorrow in the supplementary list. Okay.
Right.
Yes, number to be in list. Yes.
My lord, sentenced to undergo RI imprisonment for 3 years and fine of rupees 10,000 only, and in default, whereof to suffer undergo RI for 2 months. For
Operative parties.
My lord, that paragraph 2, my lord, page 3.
Operative party, personal judgment.
My lord, last portion, my lord. The convict, paragraph my lord 99.
99.
Page 65.
Pardon.
The convict, namely Siddheshwar, Ashok, Mukund, Venudhar, and Harihar, are sentenced to undergo rigorous imprisonment for 3 years and fine of rupees 10,000 only, in default whereof to suffer rigorous imprisonment for 2 months for each of the offence punishable under Section 13(2) of the PC Act 420, 468, and 477A of the IPC, and to undergo rigorous imprisonment for 2 years and fine of rupees 5,000 only in default, whereof to suffer rigorous imprisonment for 1 month for each of the offence punishable under Section 120B and 471 of the IPC and subject to set up under Section 428 of the CRPC. If
Okay,
happened,
as it appears, 5 persons face trial.
my lord,
So now this appeal has been filed by 3 persons.
my lord.
Okay, what happened to the other 2? Acquitted or what?
No, no.
No, my
Okay,
lord.
all of them have been convicted.
My
And you were on bail during trial?
Yes, yes, ma'am. Yes, ma'am.
Yes, Mr. Das?
Yes, I will file my appearance memo by the end of November, my lord.
All right.
There are holidays in October, so
Admit call for the trial court record. Mr. Das is present. He was on bail. They were on bail. Bail allowed. Stay realization of fine. File the appearance memo by end of November 2023. Yes.
Free copy of
of the order be handed over.
Obliged.
item number 3.
May I please your lordship, my lord?
May appellant convicted under section 13(2) read with 13(1)(d) and 7 of the PC Act sentenced to undergo RI for 3 years and a pay of a fine of rupees.
What is the operative part of the judgment?
Page number, internal page 51.
Huh?
Internal page 51. 51.
Internal page 51.
The convict is sentenced to undergo RI for a term of 3 years of the offence under section 13(2) read with 13(1)(d) of the PC Act and fine of rupees 5,000 in default to undergo RI for a period of 2 months as the offence under section.
You were on bail during trial?
Lordship.
Yes, Mr. Das.
Yes, I will file November. Right. End of November.
As on bail allowed. Stay realization of fine. File the appearance memo by November. And yes.
Free copy of the order.
Free copy of the order.
Item number 6.
Lordship pleases, my lord. My lord, here the appellant stands convicted under 20B2C The operative part being at running page 61, Your Lordship sees conviction for 10 years RI.
Wait. Which page?
Running page 61, it is
61.
impugned judgments, internal page 47.
Okay, 1,20,000 B2C. Right. Admit call for the trial court record interim application for bail and stay realization of fine to be considered after receipt of the trial court record. Yes.
The early date, Your Lordship.
Bail application of stay that will be considered after
Lordship.
receipt of the
Yes.
trial court record. You supply the deposition copies to the
Lordship.
counsel.
Grateful. I'll do that.
सब गुड़ा के deposition copy लिख देवे हाँ.
Item number 7.
May I please?
Yeah.
Conviction under section 7 and 13 to reduce 13(1)(d) of the Prevention of Corruption Act, period of 2 years and a pay of fine of rupees
Page.
75 page.
75. RI for 2 years, fine 5,000 in default under so and so. And RI for 3 years, 5,000 in default under concurrently. You are on bail.
Lordship.
Yes, Mr. Das.
Yes, ma'am.
Admit is on bail granted. Stay realization of fine. You have filed the
No, by end of November.
November end. File free copy of the order behind it.
My name may kindly be reflected in the
Yes.
cause list, my lord. All the cases.
All the cases.
Obliged.
Name be reflected in the cause list. Yes.
Item number 8.
May I please, Your Lordship? The appellant is convicted under section 363, 360.
Item number 9.
May I please, Your Lordship? Lord, this is an application of section 394 of the Criminal Procedure Code filed by the legal heirs of the deceased appellants, my lord, seeking leave to continue the appeal, my lord, because the appellant number 1, Udainath Swai, was a government high school teacher, my lord. Since after FIR was lodged, he was put under suspension, my lord, till his retirement in the year 2006. He was only getting his half salary, my lord.
No, it's all right. There are two appellants, right?
My lord,
So
both
one
have died.
is, huh?
Both have died,
No, it's all right. So they are husband and wife.
husband and wife.
So what is the conviction and what is the sentence?
Conviction, my lord, initially they were facing trial for the offense 304B 498A.
Yes.
34 of IPC and read with section 4 of the DP Act, my lord. But conviction was for 498A to both the appellants to undergo 3 years RI and in default 6 months, and then 1 year for DP Act, my lord. And other accused persons have been acquitted, my lord.
Okay. So now who is the petitioners in this IA was
My lord,
filed?
my lord, the legal heirs, sons and the daughter of the appellants, my lord.
So when the death took place, one died in 2013.
My lord.
And the other died on 2022.
My lord.
So there is inordinate delay. You have filed the delay condonation application.
My lord, only 43 days delayed.
But 43. Once this death is in the year 2013, you are to file the application within 1 month.
My lord.
So what about the appellant Asalata Swai?
My lord, Asalata Swai died in the year 2013, my lord, mother.
केते दिन भीतर फाइल करिया कथा
1 month.
आता केबे फाइल कर जंदी एटा
But
2022 रे फाइल कर जंदी
but since the appellant number 2 Udainath Swami was the government employee and the benefit of Udainath Swami, the father.
So that is the reason for condoning the delay. If once one appellant is dead, that is appellant number 2, appellant number 1 is alive. So that means you mean to say that he will continue the appeal without taking the leave of the court.
Well, mother was died in the year 2013, my lord, and father died in the year 2004
Yes,
to
Mr.
2022, my lord.
I think he is placing only for that father.
Father, my lord, because he was a government employee, my lord, and the benefit will go to the legal heirs out of the all retirement benefit.
You have stated for both.
So, my lord, Asalata was a housewife, my lord.
You don't want to se katha nohe je apano do you want to continue the appeal so far as appellant number 2 is concerned?
My lord, my lord.
So that is why the question is asked that when appellant number 2 died on 9/6/2013, why you did not choose to, because he was not serving. Now why are you again interested to continue the appeal when no benefit you will get?
Appellant number 1 Asalata Swami was a housewife, my lord.
Appellant number 1 टा Asalata Swami नहीं, appellant number 1 टा होची Udainath Swami.
But absolutely there is no necessity to continue the appeal since Udainath Swami was a government employee, my lord. All his service benefits are left with the government unless until the appeal is disposed of. How it is the result?
541 of 2022. This is an application under section 5 of the Limitation Act for condonation of delay in filing IA number 540 of 2022, which is an application under section 394 CRPC seeking leave to continue criminal appeal number 13 of 2003. After hearing the learned counsel for both the parties and taking into account the averments made in the interim application, the delay in filing IA 540 of 2022 is condoned. Accordingly, IA is disposed of. Then IA number 540 of 2022. This is an application filed by the 2 sons and daughter of the appellants to continue the appeal as both the appellants died in the meantime. After hearing the learned counsel for the respective parties and going through the averments taken and the documents annexed thereto, I am inclined to grant leave to the petitioners in the IA to continue the appeal. Accordingly, IA is allowed the petitioners be substituted in the cause title and consolidated appeal memo, consolidated cause title खाली कर दें, be filed by the learned counsel for the केबे फाइल करिवे?
Lord, next week, my lord.
Alright, by next week. So ना incorporate करिए cause title टा file करूँ, है ना?
By lord.
Yes.
Obliged, my lord.
Item number 10.
And this is also an application 394 2 my lord.
Kiye କାର death ହେଲା?
Oh, April number 3. Now the husband, the now wife and 2 sons filing application. But it was abated by the order dated.
So already abated.
By this honorable court, my lord.
So you are to file an application to recall that order also.
ତିନିଟା ଫାଇଲ କରିବାକୁ ପଡିବ
ହଁ
ତିନିଟା ଫାଇଲ କରିବାକୁ ପଡିବ
ତିନିଟା ଫାଇଲ କରିବାକୁ ପଡିବ ଆପଣ ଦିଟା ଫାଇଲ କରିଛନ୍ତି ଅର୍ଡରଟା ଆବେଟ ନ ହେଇଥାନ୍ତା ଅଲଗା ଅଲରେଡି ଆବେଟେଡ ମାନେ ସେ ଅର୍ଡରଟାକୁ ବି ରିକଲ୍ କରିବାକୁ ପଡିବ
ଭାଇ ତୁମର ପାସ over ହେଇଛି ମୁଁ ତୁମର
ୟେସ୍ କାଲି ଏଟା ଡାକିବେ 26 ତାରିଖ ଇଏ
ତୁମର
ହଁ ଏଇଠୁ ଡକାଯିବ ପରା ୱିକଲି 26
Item 11.
Please, your lordship.
The appeal has been admitted for bail. The appeal has been admitted.
Defect number 5E कौन है उरा 5E9 कौन लिखा है कौन है court fee of rupees 12 not paid name of the filing advocate in capital letter with enrollment number not one defect उड़ा remove कर दीजिए 3/7 order ହେଇଥିଲା defect to be removed हाँ काली के order देखी दियो verify कर 24/9 yes next
Item 12.
interim bail.
Yes, my lord.
देखिए 1815. What ground you have taken in this?
My lord, he
Who
is
is-
suffering from many.
Who?
Appellant number 3,
Okay.
Brismon Gupta, my lord. He is having various ailments due to high diabetic, my
देखिए
lord, and high BP. It is clearly in the report, my lord. And for which his eyes are being affected. And at any point, if the treatment won't be started, then
wait.
yes, my lord.
You know what is this report, Mr.
My
Naik?
lord.
ଆରେ ତା କଣ୍ଡିସନ ସେ ବ୍ଲଡ ପ୍ରେସର ଏତିକି ହାଇପର ଟେନସନ ଏତିକି ଇଏଟା ଏତିକି ତାକୁ ଆପଣ ମ୍ୟାନେଜ କରିପାରିବେ କି ନାହିଁ ଜିନିଷଟା ହଉଛି ଆପଣ ତାର ଟ୍ରିଟମେଣ୍ଟ କରଉଛନ୍ତି କି ନାହିଁ ସେ ଔଷଧ ଖାଉଛି କି ନାହିଁ ତାର ଦରକାର କି ବାହାରେ ଚିକିତ୍ସା ହବା ଏଇ ସବୁ ଜିନିଷ ଦେବେ ନା ତା ବ୍ଲଡ ପ୍ରେସର ୱେଟ
Only paragraph 4.
Para 4.
ହଁ
He was given treatment, proper treatment.
Treatment to be started after adequate glycemic control, which was not achieved, my lord. My lord, he
No,
needs.
he has been referred to MKCG Medical College Hospital.
My lord, tapare LV Prasad ku bhi refer hitila. His eyes are being affected, my lord. He
treatment
needs to
କରଉଛନ୍ତି
treated, my lord, LV Prasad re. And my lord, tar continuous sugar ଦେଖନ୍ତୁ କେତେ ଅଧିକା ରହୁଛି 254 ଆଉ fasting ଟା 418.
କୋଉଠି
My
250
lord, last ରେ 6 column ରେ, my lord.
fasting blood sugar.
FBS
FBS ହଉଛି 254, PPBS ହଉଛି 418.
ସେ ମିଠା ପିଠା ଖାଇ ଦେଇଥିବ ତା ପୂର୍ବ ଦିନ
My lord, 4 ରେ clearly ଲେଖା ହେଇଛି ଯେ ସେଟା ମ୍ୟାନେଜ ହେଇପାରୁନି ବୋଲି। ହେଲା କିଛି ଦିନ ଯାଉ ସେ ଟ୍ରିଟମେଣ୍ଟ ଟା କରାଉ ଏଲବି ପ୍ରସାଦ।
ଉତ୍ତରପ୍ରଦେଶ ଲୋକ ଆପଣ
ସେ ଝାରସୁଗୁଡାରେ ରହୁଛି। It is clearly
and criminal antecedent also.
my lord. Kindly
criminal antecedent ଅଛି ପରା
ସେଇଟା my lord 2000 earlier ସେଟା during his interim period, my lord, interim bail, during the trial there is no such allegation against the appellant number 3, my lord. My lord, ସେ ଝାରସୁଗୁଡାରେ ରହୁଛି। My lord, at least କିଛି ଦିନ 3 ମାସ at least
local surety ଦିଅନ୍ତୁ ସେ address verification ହଉ ତାପରେ the Mr. Naik Land Council for the government CGC files the
senior panel council,
senior panel council has produced the report of the jail medical officer circle jail Koraput as per the order dated 7/8/2023 which is taken on record. Let the land council for the appellant number 3 Brismon Gupta supply the names, address and documents up to local sureties to the land and council for verification. Please this matter କେବେ ଦେବେ ତାଙ୍କୁ within a week ଦେଇପାରିବେ ନା ଅଧିକା ସମୟ ଦରକାର ଅଧିକା ଦିଅନ୍ତୁ ଆଚ୍ଛା within 2 weeks କରିଦିଅନ୍ତୁ ତାଙ୍କୁ ଭେରିଫାଏ କରିବାକୁ ଗୋଟେ ସପ୍ତାହ ସେ ପଠେଇବେ ସେ ତାପରେ ଝାରସୁଗୁଡା ପଠେଇବେ so it may let this matter be listed on 16th of October 2023 so ऐसे आईए टा देवे इटा होची आईए नंबर 1815 of 2023 लिखिए this is an interim application for bail of appellant number 3 है ना
yes ma'am.
Yeah.
Item number 18.
Item 18 for 2 weeks after.
Right, Mr. Suchit Kumar Naik, Land Council, appearing for the appellant, 6 for adjournment For 2 weeks, huh? Urgent the case.
Obliged.
Item 19.
19, Lordship, 2 weeks after.
Okay.
After puja vacation, my lord, it is a stay of conviction, my lord. I have already filed my objection.
Mention is made on behalf of the appellant to adjourn the matter. Current counsel appearing for the appellant 6 for an adjournment. Mr. Sanjay Kumar Das, learned standing counsel for the Vigilance Department is present. List this matter after ensuing Durga Puja holidays.
Item number 20. May I please, my lord. The appellant has been convicted for under section 20B of NDPS Act and has been directed
20B
to
20B 20B.
NDPS Act, my lord.
20B ର ଅଛି ସବୁ ନା
2C.
2C Act commercial quantity.
My lord. Conviction is for 10 years and 1 lakh fine, and I have applied for bail. I am not placing the bail application of appellant number 2. I am placing for the bail of appellant number 1, my lord.
সেই ଗୋଟେ
application ରେ ଦି ଜଣ ଯାକ ଅଛନ୍ତି.
ଦେଖନ୍ତୁ IN number 1017 of 2023. Though this interim application has been filed for bail for both the appellants, but the land counsel for the appellant submits that he doesn't want to place this interim application so far as appellant number
2 is concerned.
2 Sangi is concerned. Accordingly, this IA in respect of appellant number 2 stands disposed of. Yes.
So for the appellant number 1 is concerned, he is in custody since 25/11/2019. He is the driver of the bus, and for interim 3 months period, he was released on bail during the period of trial. As on date, he is more than 3 years 7 months in custody, and nothing has been seized from the exclusive possessions of the appellant. My lord, may kindly have a glance to the deposition of the independent witnesses 5, 6, and 8.
ଆପଣ ପୁରା ବସ୍ ର ଯୋଉ
The
ଡ୍ରାଇଭର
pickup van. I am owner driver of a pickup van.
ହଁ ସେଇ ପିକଅପ୍ ଭ୍ୟାନ୍ ରେ ଯାଉଥିଲା ତ କମର୍ସିଆଲ କ୍ୱାଣ୍ଟିଟି ଗଞ୍ଜା
ହଁ ମୁଁ ଭିତରେ ଥିଲି, ସେମାନେ ଡାଲାରେ ଥିଲେ ସବୁ।
ଭିତରେ ଥିଲେ 11ଟା ଜରି ବସ୍ତା ଭିତରେ ଥିଲେ କଣ ବାସ୍ନା ବଢିଆ ସୁନ୍ଦର ବାସ୍ନା ହଉଥିବ ଆଉ ଭିତରେ ଥିଲେ କଣ
ସେଇଟା ଇଣ୍ଡିପେଣ୍ଡେଣ୍ଟ ୱିଟନେସେସ୍
ଇଣ୍ଡିପେଣ୍ଡେଣ୍ଟ ୱିଟନେସ୍ ଏନଡିପିଏସ୍ ରେ କୋଉଥିରେ କରନ୍ତିନି ତ ସପୋର୍ଟ କରନ୍ତିନି ଆଉ ରୁହନ୍ତୁ ହାଫ୍ ଅଫ୍ ଦି ପନିଶମେଣ୍ଟ ରୁହନ୍ତୁ ତାପରେ ସେଇଟାକୁ ଆଡଜନ କରିଦିଅନ୍ତୁ। ୟେସ୍ ନେକ୍ସଟ stay realization of fine good.
Item 26. 6 minutes pass.
26, I have already filed my objection, my lord. It is a stay conviction. In both the cases, I have filed and served the copies on Mr. Misra on 22 Friday, last Friday.
All right. No, it's all right. He just want Passover.
No, I am submitting this Friday. I have filed my objection. Today is Monday. On Friday, I have filed my objection.
It has not come on record.
No, I think on 22 Friday.
Mr. Sanjay Kumar Das, learned standing counsel for the Vigilance Department, submits that he has filed his objection to the interim application for stay of conviction on 22/9/2023. Since the objection is not available on record, put up this matter next week along with the objection filed by the Learned Standing Counsel for the Vigilance Department.
Copy has been served, my lord, on the same day.
And copy has already been served.
In both the appeals, my lord, connected appeal is there 635.
Order share.
Sei dino file ହେଇଛି.
Objection file matter to be listed 3/10/2023. Yes.
Yeah? 376.
376 simple ना किछ नहीं था धरे.
376 2 I and 6 of the POCSO.
Three 2N and 6 of the POCSO.
Imprisonment for on
6
POCSO.
6 POCSO RI for 10 years.
10 years.
All right. This is item number CRL. Okay. 666 of 2023. You are on bail during victim is
PW3.
Doctor.
Doctor not examining. Doctor not examining.
Kahin कौन allows?
Denied for
PW5 is the eyewitness.
अच्छा eyewitness गुड़ा अच्छी.
Yes.
PW5. अच्छा 3 number तो बस हूँ.
सही. Holy. My 21 is that eyewitness.
He says that I do not know the person who is shown to me.
Again.
Court रे से ताकु देखा गला मन्ना कला Mr. Tripathi.
Yes, sir.
I do not know the person who is shown to me.
Again.
The incident took place on while standing on the veranda swan. So a person being named as Chandan possibly took me swan. So I knew him subsequently. That Chandan is inside here at Audible. Only get again, coach. audible distance. The person who was shown to me earlier is the said Chandan.
But then his 164 statement was recorded. I have annexed that page.
No, ये कहाँ की? हाँ?
Page
complete ये तो नहीं? Evidence टा? कौन सा बोलते हैं? ये 2 number paragraph पर 9 number paragraph.
64.
Wait. The position. Who paragraph କହୁଛନ୍ତି? Which paragraph you want to place? In the chief examinations, he stated that
in the my lord, cross examination select para 30
Chandan took me on his bike to Firingia, where his uncle Prakash and aunt were residing.
My lord.
And I was kept in the house of Prakash.
My lord.
And parents of Chandan were available. 3 days after my stay in such house, the parents and uncle of Chandan made me married forcibly to Chandan. Thereafter, Chandan kept physical relationship. So this is the version.
My lord.
How कौन कहले आप?
My humble submission in the 164, my lord. He has not stated, my lord, your lordship may can have a glance to page 55.
60?
55, 55. Annexure 2 series.
55. कौन कहले?
He has not stated anything, my lord.
ମୁଁ ଚନ୍ଦନ କୁମାର ସ୍ୱାଇଁଙ୍କୁ ଆଗରୁ ଭଲ ପାଉଥିଲି। ମୁଁ ମୋ ଇଚ୍ଛାରେ ଚନ୍ଦନଙ୍କ ସହିତ ବାଇକରେ ବସି ଭୁବନେଶ୍ୱର ପଳେଇଲି। ପ୍ରଥମେ ଚନ୍ଦନ ବାଇକକୁ ନିଜ ଘରେ ରଖିଥିଲେ, ତାପରେ ଆମେ ବସରେ ଭୁବନେଶ୍ୱର ଗଲୁ। ମୋର ଚନ୍ଦନ ସହିତ ଭୁବନେଶ୍ୱର ମନ୍ଦିରରେ ବାହା ହେଲା। ତାପରେ ଚନ୍ଦନ ସହିତ ଭୁବନେଶ୍ୱରରେ 2-3 ଦିନ ପର୍ଯ୍ୟନ୍ତ ଗୋଟେ ସାଙ୍ଗ ଘରେ ରହିଲୁ। So the only problem is about the age.
Yes, my lord. The age is, my lord. So far, age
The
is
finding of the age, Mr. Tripathi.
Yes.
My lord, age
PW7.
28/12/2002, my lord. His age.
When the occurrence took place.
Occurrence took place, my lord, on 2017/3/2018.
17/3/2018.
My lord.
तामाने 15 ବର୍ଷ କେତେ ମାସ ଚାଲିଥିଲା ଆଉ କଣ?
That, my lord, the admission register is from the high school, not from the primary school, where the initially he was admitted.
ଡାକ୍ତର ବାବୁ କଣ କହୁଛନ୍ତି?
Doctor examination.
ହେଇନାହାନ୍ତି।
ନାଇଁ।
ଝିଅ ଡିପୋଜିସନ କେବେ ଦେଇଥିଲା? 2000 କେବେ? 19?
14 ମାର୍ଚ୍ଚ 2019।
ଆଚ୍ଛା। 4 ବର୍ଷ ହେଇଗଲାଣି ଆଉ। ବାହାଘର ହେଇଗଲାଣି ଝିଅର? ହେଇନି?
ଜଣା ନାହିଁ।
ଅଲଗା ଅଲଗା ରହୁଛନ୍ତି, ବାହା ହେଇଯିବ ଝିଅ।
ନେଇ ଆସନ୍ତୁ, ଏଟା ଷ୍ଟାଟସଟା ନେଇ ଆସନ୍ତୁ, ଆର ସପ୍ତାହରେ ନେଇ ଆସନ୍ତୁ। The Learning Council for the state seeks some time to obtain the status of the victim. This matter next week. That is 3rd of October 2020. Written 8 out of 4 cases of hon'ble, right? Yes.
Next week one. Next Tuesday.
Tuesday, 3rd of.
Oblige.
Item 30.
May. My lord. Here also, my lord, the victim denied for medical examination. And EW2.
Deposition copy দিয়ে দিয়েছেন?
Again. EW2 is the victim.
ठीक है, ठीक है. It was CRLA 7/1 of 2023. You were on bail during trial. Victim?
EW2, man.
Doctor? Not
Doctor
examined.
not examined. They denied for medical examination.
Sentence?
10 years.
6 POCSO.
6 POCSO. देखिए victim রা দুই আসুন victim evidence କୁ আসুন
EW2
ହଁ 25 ବର୍ଷ କହୁଛି
ଇଏ ରେ ସେ
वो
କହୁଛନ୍ତି
जो
ବାପ
occurrence took place 8 years back actually.
ଆଉ ବାପା ମା ମଧ୍ୟ କହୁଛନ୍ତି ଯେ
Called over the phone, advised me to leave in my house. Accordingly, I left the house. Accused took me to village once, so kept me in the house of unknown person. Assured me to get married. Thereafter, took me to Khandagiri. Rented house, physical relationship, treated as husband and wife. तारो एविडेंस अनुଯାୟୀ 17 ବର୍ଷ ହେଇଯାଇଥିଲା ମିଷ୍ଟର
Yes, Mr. 17 years old.
61
କାରଣ 25 ଅଛି ତାର ଏଜ କହିଲା ଘଟଣାଟା ଯଦି ବି 8 ବର୍ଷ ତଳେ ତାକୁ ଯଦି ଆକ୍ସେପ୍ଟ ହୁଏ ତାହେଲେ ଏଫଆଇଆର ଟା କେବେ ଦିଆଗଲା ଆଚ୍ଛା 2014 ମସିହାରେ
14 ମସିହା
ତାର ଡେଟ୍ ଅଫ ବାର୍ଥ କେତେ ଆସୁଛି
ଡେଟ୍ ଅଫ ବାର୍ଥ 97 24/6/97 16 ବର୍ଷ 8 ମାସ 10 ମାସ
17 ଚାଲିଥିଲା ତମର
ମଦର ମଧ୍ୟ କହୁଛି ତାକୁ 18 ଇୟର୍ସ ହେଇଥିଲା ଇନସିଡେଣ୍ଟ ବେଳେ ଏଜ୍ 61 years.
All right. Heard the learned counsel for the petition, learned counsel for the state. Considering the submission made by the learned counsel for the petitioner that the petitioner was on bail during trial and he has never misutilized the liberty while on bail, and after going through the evidence of the victim bracket PW2 and the fact that the victim has refused for her medical examination, for which no doctor has been examined in the case. After hearing the land counsel for the state, I am inclined to release the petitioner on bail allowed stay realization of fine. Yes.
Item number 31.
Hello. That was on bail during trial.
Kutre conviction kutre ichi.
Conviction
6 POCSO, 10 years.
10 years.
He has not given the
Deposition copy.
Yes.
Deposition date. Deposition.
Annex କରୁଛନ୍ତି ପଛରେ ଏଇଟା ତ 154
ସେଟା କାରଣ
yes yes
my lord in the 164 statement
Wait. So this is CRLA 762 of 2023. It's a 10 years.
Yes, sir.
You are on bail.
Wait, different trial.
Who is victim?
PW1.
PW2. One.
One is a victim. And doctor?
Doctor.
PW8.
Conviction କୋଉଥିରେ ହେଇଛି?
6 POCSO.
6 POCSO ହେଇଛି.
Victim କହିଲା ମୁଁ 23 ବର୍ଷ ବୋଲି ଓ ଯେ ଯୋଉ ଘଟଣା ବେଳେ କହିଲା ମୁଁ 14 ବର୍ଷ ଅଛି.
My lord, the mother of the victim told that at the time of occurrence she was 18 years old. And also doctor also told 08 on the cross examination that she was 18 years old.
କାଇଁ ତାର ଇଏ ପ୍ରମାଣ ହେଇନି କି?
Yes. PW7. School register.
କେତେ ଆସୁଛି ତାର?
2797.
2797 ବେଲେ ଘଟଣା କେବେ ହେଲା? FIR ଦେଖିଲେ? FIR ଆସୁଛି 7/1/2013 ହଉଛି ଡେଟ୍ ଅଫ୍ ଅକରେନ୍ସ. ତ ଇଏ ହେଲା 13 ବର୍ଷ. ସିଏ ଆଉ 3 ବର୍ଷ 98 19 2000. ମାଇନର ହଉଛି.
My lord, kindly send to 164 statement, my lord.
He kept me for about 6 months, and during these 6 months he kept physical relationship with me against my willingness.
164
कौन 164 ରେ କହିଛି?
କହିଲା ଆମ ଘରେ ମୋ ପାଇଁ ବାହାଘର ଠିକ କରିଥିଲେ, ମୁଁ ସନ୍ଦେହ କଥା କହିବାରୁ ମତେ ଆମ ଘରେ ବାଡେଇଲେ ଓ ହାଣିଦେବେ ବୋଲି କହିଲେ, ସେଥିପାଇଁ ନିଜେ ଇଚ୍ଛାରେ ମୁଁ ତା ସାଙ୍ଗରେ ଗଲି. ଏତିକି ମାଇଲ ଏତିକି କହିଛି.
ଆଉ 10/1/2000 paragraph 5 ରେ କହୁଛି they got married in a Shiva temple ବୋଲି କହୁଛି. Mr.
Yes, sir.
164 କିଛି କହିନାହିଁ.
Minor ଟା କହୁ କି ନ କହୁ ତାର କଣ ଅଛି ତୁ?
No minor, no prior acquaintance with Sanjay. I have no prior acquaintance with Sanjay, so and so. We went to Kerala by କଣ କେରଳ ଯାଇଥିଲେ ନା କଣ?
Yes, sir.
Kerala by
Staying
train.
together at Kerala.
He kept me in Kerala for 6 months. Okay. All right. Heard the Learned Counsel for the petitioner, Learned Counsel for the state. The Learned Counsel for the petitioner submitted that the petitioner was on bail during trial and he has never misutilized his liberty. He submitted that the victim has stated in her evidence that he got married to the petitioner in a Shiva temple, went to Kerala with the petitioner and stayed there for 6 months. And during these 6 months, the appellant was keeping physical relationship with her on daily basis. It is further argued that the petitioner has good chances of success in the case and balance of convenience is in his favor, and therefore the bail application may be favorably considered. Learned Counsel for the state, on the other hand, opposed the prayer for bail and submitted that the entry in the school admission register, which has been proved by PW7, indicates that the victim was minor as on the date of occurrence. Peruse the evidence of the doctor, bracket PW8, considering the submission made by the Learned Counsel for the respective party, nature of evidence adduced, fact that the appellant was on bail, petitioner was on bail, absence of any material that he misutilized is liberty and absence of any chance of early hearing of the appeal in the near future. I am inclined to release the petitioner on bail, stay realization of fine. Yes.
May I please? Yeah. The petition appellant has convicted under section 20B IC of NDPS Act.
Custody certificate को आई थी लगी आने अपन.
Yes, well. Yes. In the meantime, 7 years.
को order दिया इतना custody certificate.
21/8/2023.
हाँ?
21 to 14/8/2023.
हाँ. कितने आसिला देखिले? A plus B plus C थी वो.
Same thing किसी करना.
करना दी. अने instruction देवे ना वो. नहीं ये तो ये मु कौन ये कैलकुलेटर दर हिसाब करी मिना कौन. देखो हिसाब को ना दी केते. एटा काली के आसियो. तो हिसाब करी मत कौन. काली के 26.
Yeah.
9/20/20.
Item number 36.
Lord, the SCST appeal, my lord. The petitioner is in custody, my lord, since 11/8/2022, my lord.
আসছি কেস ডায়েরি আসছি
Yes, my lord. And last occasion, the petitioner filed comprehensive affidavit, my lord.
wait PRLA 401/2023. So since when you are in custody?
Custody, my lord, 11/8/2022. In the meantime, my lord, similar.
Notice sufficient?
Yes.
Yes, my lord. For 1/6/5.
Notice sufficient. Okay. What are the offenses under which charge sheet submitted?
302,
Okay.
120B,
Hmm.
C2B, SCST.
Name of the deceased?
Robbie's.
Robbie?
Robbie. My lord,
Mr. Tripathi?
Robbie Singh.
Date of occurrence?
Date of occurrence, my lord, 19 18/12/21.
18/12/21. So eyewitnesses are there?
Informant, my lord, the eyewitness dead, my lord. In rejection order mentioned in this ground, my lord. Other similar footing to accused lordship granted also.
Who has been granted bail?
Granted, my lord.
Copy ଦେଇଛନ୍ତି?
Yes, my lord. Copy ଦେଇଥିଲି
wait.
ମଝିରେ S.K.SAHOO seal ର last. Third page ରେ seal ର last କୁ ଅଛି S.K.SAHOO, Sheikh Amir Hussain, and my lord, the present Sheikh Haider. 3 persons religion bail.
The informant, who is also an eyewitness to the occurrence, and he has specifically stated that 4 accused persons, namely so-and-so, caught hold of the deceased and accused Sheikh Yusuf dealt knife blow, as a result of which deceased died. Learned counsel for the appellant submitted that some of the co-accused, namely so-and-so, have been released on bail by common order. Learned counsel for the state opposed the prayer for bail and praised the statement of the informant. However, does not dispute that there is no criminal antecedent against the submitted, that there are materials on record relating to the conspiracy part, but he fairly submitted that similar allegation is also against co-accused ones who have been released on bail. So ଏଇ ଯୋଉ ଲୋକଗୁଡାକ କଠୋଲ କଲେ ଆଉ ଯିଏ ଛୁରୀ ମାରଲା ତା ଭିତରେ ଆପଣଙ୍କ ନାଁ ନାହିଁ?
ନାଇଁ, ଏମାନେ ଖାଲି ତା occurrence ଆଗରୁ gathering ହେଇଥିଲେ
Just a minute. ଲୋପା alias ରୂପା alias ଶେଖ ଜଣେ ଅଛି ନା କେତେ ଜଣ?
ଜଣେ ତାର alias ହେଇଛି, ସେଠି FIR ରେ ଅଛି.
Mr. Tripathi, ଏ ଲୋକ ନାଁ ନାହିଁ, ସେ ଯୋଉ ଧରିବା ଲୋକ ଆଉ ସେ ଯୋଉ ଛୁରୀ ମାରିବା ଲୋକ?
ନା, assault part ଟା ତଳେ ଅଛି.
ହଉ, ତାହେଲେ ଏଇଟାକୁ ସେମ୍ ଫୁଟିଂ କରିଦେଇକି ଆଲାଉ କରିଦିଅନ୍ତୁ. ବାକି କାଲି ନବା ସବୁ ଥାଉ, ସେ ମନା କରେନି।